All right. 14A District Court for County of Washington, State of Michigan is now in session. All those that are the court draw near, the Honorable Judge J. Cedric Simpson.
You may be seated. And Mr. Cook.
Morning, Your Honor. Raymond Cook for the people. Your Honor, the people would waive any potential conflict between this honorable court and the office of the public defender. While the people do not believe that any such conflict exists, we make this waiver in the avoidance of all doubt.
All right, thank you. And
Michael Gaddy, Assistant Public Defender. Your Honor, I would concur with Mr. Cook that we do not believe that any conflict exists. And to the extent that any may arise or occur or be in existence, we would waive any such conflict.
all right, the court for its part also does not believe there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of People State of Michigan versus Tamika Slip.
Good morning, Your Honor. Some people here. Hello.
Hello, Ms. Slip.
Good morning, Your Honor. Isn't that such a nice reading first thing on your dock?
It is. It is.
Spring and raise the sunshine here to you. Christina Costantino appearing on behalf of Ms. Schlip. Tamika, can you please state your name for the court?
My name is Tamika Joy Ship.
Thank you.
You're
Your
welcome,
Honor,
Mr. Simpson.
This is the date and time set for a PCC. We are asking for a brief adjournment of the PCC. It's my understanding there is some videos that are going to be coming our way discovery-wise, and I also need an opportunity to have some further discussions with Ms. Schlip.
I am here now.
The videos are they on their way or? Okay. Then you got to get them and then somehow get to Ms. Slip and do all of that.
You're adjourned.
Will the 16th be enough time or you need more time than that?
I think the 16th should be good, Judge.
All right. Probable cause conference will be adjourned to July 16th, 2026, 9 a.m. Bond will continue.
Thank you very much. Ms. Schlip, I'll see you tomorrow.
You're coming to the appointment?
I have a visit with you for tomorrow.
Okay. And this is everything you have going on. I love you, buddy. Bye.
Take care.
Thanks.
Thank you. Court calls the case, People versus Joshua White.
Ready to go.
Michael Gaddy, Assistant Public Defender on behalf of Mr. White, Your Honor. He is,
Oh, there he
I
is.
believe he's appearing,
Mr. White, can you state your name, please, sir?
Joshua White.
Thank you. All right, what are we doing?
Your Honor, we'd like to set this matter for an exam.
Discovery is complete.
To the best of my knowledge.
All right. And where facility is,
Might be in Milan.
pardon?
Are you in Milan, Mr.?
I'm in Hazelton, West Virginia.
He's in West Virginia.
Your Honor, if we could have 4 weeks,
Not a problem.
thank you.
All right. And so if I set it, well, the 28th. All right, preliminary examination in person will be set July 28th, 2026, 9 a.m. before Judge Fresh Hour.
Thank you, Your Honor.
Bond continued. Thank you. Thank you, Mr. White.
Thank you. Have a great
You too. Court calls the case, People versus Demond Bransford.
Good morning, Your Honor. Trovia Star On behalf of Mr. Bransford, the Bransford Station.
Demond Bransford.
Thank you. Your Honor, a few things here. One, we would like to set these matters, because there are two matters, for exam.
Okay.
Two, we would like to address bond. And third, depends your decision. Well, there's another bond issue as well that we'd like to address separate from this case. That's before you.
All right. What date am I? All right. When people have their witnesses available July 7th.
We'll do our best, Your Honor.
All right. Discovery is complete.
Discovery is complete. Is it possible to have July 14th?
Any objection from the
No,
preliminary examination in person will be set July 14th, 2026, 9 a.m. before Judge Garwood. As to bond.
Yes, Your Honor. One moment. I believe Mr. Bransford's bond right now is $50,000, 10%. $50,000, 10%, I believe. We're asking if possible if the bond can be reduced. Mr. Bransford is 25 years old. He has a child on the way. If he's out, he'll be able to resume his job at Taco Bell, and he'll be living with his mother. We understand the allegations in this case, and that these are two felonies, and that he has other matters as well. We're asking if possible if this bond can be reduced from $50,000, 10%, to $10,000, 10%.
Response.
So I'm not sure, I think I'm sure the court is aware the last time Mr. Bransford was here, his jail calls were addressed in which he was calling the victim directly and having others call on his behalf, saying that he said, tell your mama to tell that his mama will pay her to write the judge and tell him that we didn't do that. Is there any way someone can take back what they said to the police, saying that to the victim? So I would have concerns that he can't follow court orders, given that he was in custody, potentially committing witness interfering, that needs a little bit more investigation and could potentially be added at exam for Mr. Bransford. So at this point, I would be objecting.
Anything else?
Nothing further on this second issue.
Motion for bond reduction is denied.
And then finally, Your Honor, in case 261071 SM, that's a misdemeanor matter. It's not up for today. I will be sending over a stipulation of order to increase his bond on that.
And I read this before, Your Honor, on the figured out for assault at the jail. Not sure.
So someone posted bond in that case. So he's not receiving credit on that particular case. So I'm submitted.
All right. Well, it seems to me if you talk to the prosecutor on that, and you can deal with that. All right. Thank you.
Thank you. All right.
Court calls case of People versus Joel Brickley. I'm sorry.
As on behalf of people around.
Creature. Where's the defendant?
Sure.
Good morning, Your Honor. Marcia Page on behalf of the defendant. I apologize, Your Honor.
Do you have any knowledge as to where he is?
I'm not sure the case. Is that Mr. Bricky?
Yes.
No, I do not, Your Honor. I was trying to contact him at the moment. He was at the last court date. And so, and did have contact with him. I'm not sure why he's not here. I would ask the court to allow me to make an attempt to call him.
Bench warrant will issue bond 10,000 cash surety. That warrant will issue immediately. Thank you.
Thank you, Your Honor.
Court calls case of the People versus Andra Hunter.
Good morning, Your Honor. Again, Trovius on behalf of Mr. Hunter Jr. Mr. Hunter Jr., state your name.
Andra Hunter.
Your Honor, my client is urging me to set this matter for an exam. Discovery is not complete. I should be okay. but discovery is not complete.
What's missing?
Well, I was just appointed to this case yesterday, and I made the discovery request, and I've informed.
You don't have any.
I don't have anything. I've informed my client that the best way possible is to adjourn it so I can get the discovery.
Who had the case before?
The PD's office. They did send me something, but I just got this case yesterday late afternoon. But again, my client is urging set this matter for an exam.
Is that correct, sir?
Yes.
Understanding that your attorney may not be ready?
Yes. And when appropriate, Mr. Hunter would like me to address bond as well.
I'm going to mark in the file that there'll be no adjournments for any discovery issues. That's going to be on you guys. People have their witnesses available the 7th or the 14th. We're going to have to go to.
14th would be great. Thank you.
Preliminary examination in person, July 14th, 2026, 9 a.m. before Judge Washington.
Your Honor, I believe Mr. Hunter's bond right now is no bond. Mr. Hunter, he's 33 years old. He has a total of 4 children. His family is in the courtroom. He resides with his children, his girlfriend, himself, of course. He works for construction with his uncle. I believe he has a violation of probation case. Yeah, I know he has a violation of probation, I believe related to this, but I'm not sure. And I was just appointed to that one. That's up on July 7th in front of Judge Conkey, the circuit court. We were asked that.
Where do you get no bond?
That's what my client told me.
Well, he's obviously not telling you the truth.
But what is his bond, Your Honor?
It's 1,000 cash surety.
I'm sorry, say that again?
1,000 cash surety.
Tell them we already paid 1,010%. Dollars, and I was supposed to get a tether.
Oh, okay. Your Honor, I would ask if the bond can be amended to a 10%, $1,000, 10% along with the tether.
Any response on these charges? Any response from the people?
Have they even said anything about self-defense?
Over here for
Application.
Say the for example. I'm sorry. Maybe should be able to.
It already is. I don't know why you're wasting my time. His bond is already 1,010%.
Told me I was.
Motion for bond reduction is denied. I don't even know why we had to hear that. Thank you. We're done.
Heard it from me. It's $1,000, 10%.
I'm sorry, Your Honor. Was it set for review?
I said it. Yeah,
14.
Okay, so sorry.
that's all right. 14th before Judge Washington, I think.
Thank
Court calls case People versus Benjamin Coleman IV.
Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Marcia Creighton on behalf of Mr. Cook, who I believe is via Zoom, Your Honor.
Benjamin Coleman.
There we go.
Didn't pick him up. Say your name again.
Benjamin Coleman.
All right, I got him here, but not there. All right. Okay, he's on there. It's on Zoom.
All right, Your Honor, we will be asking for a preliminary exam in this matter. Discovery is complete. Additionally, my client has a request that he would like to attend that preliminary exam via Zoom.
Absolutely not.
Thank you, Your Honor. I thought I would tell him I would ask.
Coverage complete. People have their witnesses available the 7th.
Or best, Your Honor.
Preliminary examination, July 7th, 2026, 9 a.m. before Judge
Judge Freshour.
Freshour. That is in person.
Thank you.
Bond continued. Thank you.
Thank you.
Court calls case People versus Alfred Wright.
Your Honor, Raymond Cook for the people.
Good morning, Judge. On behalf of Mr. Wright, Attorney Nicholas North, PA 642. I believe Mr. Wright, yeah, he's in the jail. Mr. Wright, when you have the chance, please state your full name.
That's okay. You'll get yourself out here, Mr. Wright.
Alfred Wright.
Thank you, sir. What are we doing?
Judge, can I please ask for an adjourned PCC? We don't have all the discovery yet. I just got the case a couple days ago.
Without objection, probable cause conference will be adjourned to July 9th, 2026, 9 a.m. Bond continued.
Thank you, Judge.
Thank you. You're all set. Oh, did you hear what happened? You didn't?
No, and I'm supposed to be out, but it's about the phone.
I'm sorry?
I'm supposed to have a phone in order to get out on the tether.
Right. But I don't. So what are you asking from me?
No, I'm saying it's supposed to be put in my property. And I'm supposed to be out.
So you have a phone in your property?
No, I'm getting one put in there.
By who?
I don't even see him in here, but he's my attorney.
Did he leave already? Sir, I think your attorney, he was on Zoom and I think he's left.
Yeah, he said he was going to be on Zoom.
Right. But I don't know anything about him putting a phone in your property.
Well, no, he talked to me yesterday when he brought me down to the front of the office behind the booth. And he told me he was going to get me a phone so I can get out on this tether because
okay, then that's going to be between you and him. So I'm sure if he told you that, he's going to take care of it.
Okay.
All right.
Yeah.
Thank you.
Right. Yeah. Don't try to understand.
Court calls the case People versus Naya Lee.
People.
Christina Costantino appearing on behalf of Naya Lee. Ms. Lee, can you unmute and state your name for the court?
Naya Lee.
Okay, there she is. All right.
Your Honor, this is a date set for PCC. Thank you very much. There is a case that this case is tracking that's up at the circuit court. That matter is scheduled for July 13th. So we would ask for an adjournment of the PCC to a date after July 13th.
I think we set your other one for the 16th. Will that work then?
Yes, Judge, that'd be great. Thank you.
Without objection, probable cause conference will be adjourned July 16th, 2026, 9 a.m. Bond continues.
Thank you very much, Judge. Have a good rest of your day.
You do the same.
Thank you.
Court calls case of the People versus Antoine Taylor.
Good morning, Your Honor. Nick Sarnado requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney Ashley Feltus.
He is tall. Real tall. Yeah. You should put Feltus next to him. See him really tall. No. Okay. Permission to practice is granted.
Assistant Public Defender Davi Lebo for Mr. Taylor stands to my right. Mr. Taylor, if you could state your name, please.
Taylor.
Thank you. And Your Honor, we'd be requesting substance matter for preliminary exam. Please, discovery is complete.
People have their witnesses available to 7.
Hi, Your Honor.
Preliminary examination will be set in person July 7th, 2026, 9 a.m. before Judge Perry. Bond Thank you. Court calls case People versus Kwame Edwards.
Ellie then on behalf of the people, Your Honor.
Edward Drugic on behalf of Kwame Edwards.
Your name, sir?
Kwame Edwards. And
Mr.
Your Honor,
Durkis?
I asking for an adjournment, looking for a video discovery.
Probable cause conference will be adjourned to July 16th.
July 16th?
Yes, 2026, 9 a.m.
All right.
Your bond will continue. Thank you, sir.
Thank you, Your Honor.
Court calls case of the People versus Quintez Tomlin.
Morning, Your Honor, Reed with the people.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Tomlin, who approaches. Mr. Tomlin, can you please state your name for the record?
State your name, sir.
All right. Your Honor,
Yes,
may we briefly approach on this?
you may.
Thank you.
Someone will be. I've covered. Record should reflect we had a bench conference in this case. I have received the competency report. I don't think defense counsel has received it as of yet. So, and it's asking for an adjournment. So I will adjourn the competency hearing to, will July 9th work for you, Counsel?
I think that would be just fine, Your Honor.
July 9th, 2026, 9 a.m.
Thank you.
All right. And did you need us to send you a copy?
We would love that, Your Honor, just in case.
Thank you.
Thank you very much.
Very good. So. Court calls the case People versus Napoleon Orbit.
Assistant Public Defender Duffy Lebo on behalf of Mr. Corbett, who appears from the Wayne County Jail.
Fair state your name?
Napoleon Corbett.
Corbett. Okay, gotcha. All right.
And Your Honor, we have reached a plea agreement in this matter. I'm just requesting an adjournment to get the paperwork together.
Okay. Gonna be in Wayne County for a while, or?
That is my understanding, Your Honor.
Because we're gonna need at least 2 weeks out. If he's at Wayne. So I can do the 9th.
Thank you, Your Honor.
The July 9th, 2026, 9 a.m. Bond continued.
Thank you.
Court calls, thank you, sir. Court calls case People versus Demetrius Caldwell.
Read it over to the people, Your Honor.
Demetrius. What are you lost?
Oh, he's on Zoom. Sorry, Your Honor.
Yes.
I'm sorry. Stephanie Cannon on behalf of Mr. Caldwell, who is appearing via Zoom. Mr. Caldwell, could you please state your name for the record?
Demetrius Caldwell.
Thank you.
Your Honor, we're asking that his case be set for a preliminary exam.
Discovery is complete.
Best of my knowledge.
People have their witnesses available the 7th, 9 a.m. before Judge Fresh Hour.
Thank you so much, Your Honor.
Bond will continue. Thank you. Court calls case People versus Jesse Hardman.
And Edward Durgett on behalf of Jesse Hardman.
Your name, sir?
Jesse Andrew Hardman.
All right. You're requesting an adjournment?
That's correct, Your Honor. I'm also looking for video discovery in this case.
Probable cause conference will be adjourned to July 9th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Laura Zendaya.
Requesting permission for practicing suits, 8.120 under the supervision by her prosecuting attorney and Chicago.
Thought I'd ask, what state are you from?
Oh, Maryland.
Okay, good enough. All right, permission to practice is granted.
And good morning, Your Honor, Assistant Public Defender Chinazi Carey. I can really, on behalf of Mr. and Dia, Laura, state your name for the record.
Laura Ando.
Thank you.
Judge, we'd like to set this matter for preliminary exam.
Discovery is complete.
Yes, Judge, to our knowledge.
And people have their witnesses available on the 7th.
Yes, Your Honor.
All right, preliminary examination in person, July 7th, 2026, 9 a.m. before Judge Perry.
Okay.
Bond will continue. Thank you.
Thank you, Judge.
Court calls case of the People versus Christian Bird.
Stephanie Cannon on behalf of Ms. Bird, who's approaching. Can you say your name for the court?
Christian Bird.
I have before me a plea form that indicates the defendant would be pleading guilty to an added count 2 of attempted resisting and obstructing the 1-year offense. Upon their successful plea to that charge, count 1 would be dismissed. That's the court's full understanding. Correct?
That's correct.
That's correct, Your Honor.
Never sworn, please.
Right hand. Do you solemnly swear to affirm the testimony about to give truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name, please.
Christian Bird.
All right. This court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court cost. Do you understand that?
Sir.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Okay.
Understand that? Understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Signed an advice of rights form, is that correct?
Right.
Do you have any question regarding those rights?
Am I going to rehab?
The court has already signed an order allowing her to go to rehab. It's my understanding she has been screened and you will likely be going as soon as the bed is available.
Right.
All right. So in terms of the rights form, do you have any question regarding any of those rights?
No.
You understand that you're waiving or giving up all of those rights, including the rights under paragraph 5.
That's fine.
You understand that?
Sir.
You understand you're giving up your right to appeal of right.
Okay.
You understand that?
Sir.
All right. Are you on probation?
I never was.
Okay. And you're not on parole?
No.
Correct? Okay. Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Has anybody threatened you or coerced you in any way to get you to plea?
No, no threats.
Pardon?
No threats.
Okay. You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense?
Sir.
All right. on the date of January 12th, 2026, at the location of Norman Drive in the city of Ann Arbor, Washtenaw County, state of Michigan. Did you come into contact with city of Ann Arbor police officers?
I did.
All right, what happened?
I had broken in a car.
You broke in a car?
Yeah, I was high under the influence
Tell
of
them what you did to resist.
what. I tried to. Well, we was right on the street. I was going to cross the street on Platt Street,
Okay.
and I was going to go to the house where I was staying at and go lay down because I was under.
Okay, did the police tell you to do something?
Yes, they told me to stop, and I kept trying to walk away.
Okay, and when you did that, you knew that those were police officers?
Excuse me?
You knew that those were police officers asking you to stop, right?
Yeah.
Okay, and you just did not.
And I was just.
Is that correct? You didn't stop?
Oh yeah, I didn't. No, they swung me around, slung me onto the ground.
Your Honor, I believe that's the factual basis for.
Okay.
I had.
Court does find that there is a factual basis in which the court could determine defendant's guilt by your plea. I have to explain something to you. You understand that it's between the time of sentencing and the time I accept your plea, that if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
And you got to be good between now and the plea, or they don't have to give you the plea.
Okay.
You got that?
Sir.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
Aware of none?
And have I complied with the court rule?
Yes, the court has.
Court will accept the defendant's guilty plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Sentencing will be
July 17th at 8:30.
17th.
Yes.
July 17th, 2026, 8:30 before Judge Perry. Bond will continue.
Tell you, girl, I
You.
have a doctor's appointment. Okay, but he wouldn't.
Court calls the case of the People versus Donald Baker.
Great. Give us the Jane.
President Thomas Middleton, should I be carried really on behalf of Mr. Donald Baker, Judge?
All right. Mr. Baker, can you state your name, please?
Donald Baker.
Your Honor, we're asking for an adjournment in this matter. I have been having quite the difficult time in contacting Mr. Baker. No fault of his own by far, but I'll try again and call. I've gotten everything set up and now they are charging me for the professional visit. I don't know.
They're charging you for a visit?
Yes, Judge. So I just need to call whoever's in charge, and I'll probably drop Judge Simpson's name. And
well, that's not going to. Okay. You want the 16th or the 23rd?
16th should be fine, Judge.
Okay. Probable cause conference will be adjourned July 16th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you, sir. All right. Court does call the case People versus Robert Drobashevsky.
And this is on behalf of the people.
And Assistant Public Defender, Chinazi Carey, I can rule, Your Honor, on behalf of Mr. Drobashevsky. Mr. Drobashevsky, could you state your name for the record, please?
Robert Drobashevsky.
Drobashevsky. That's right. Your Honor, we're asking, you haven't received anything, right?
It said Friday.
Okay.
They said it would be ready this Friday.
Okay. So we need an adjournment, Your Honor. A brief one would be fine. I've had some very meaningful conversations with Mr. Drobashevsky, so I know we've got to get the comp situation out of the way first.
Correct. So I will turn this back. Will that work for you?
That should be fine, Your Honor. Thank you.
All right. Comp hearing is adjourned
Thank you.
to July 2nd, 2026, 9 a.m. Thank you. Bond continued. Court calls case People versus Sean Charnley.
Michael Gaddy, Assistant Public Defender, currently on both matters, Judge. Mr. Charnley is approaching.
State your name, sir.
John Charnley.
All right, what are we doing?
Your Honor, we're asking for the court for an adjournment so that we can discussing this matter with the people.
Will the 9th work or you need more time?
I think the 9th would be fine, Judge.
Probable cause July 9th, 2026, 9 a.m. Pond Wilkins.
Thank you, Your Honor.
Court calls case of the people versus Lawrence Buckner.
Albert
on behalf of Mr. Buckner.
Your name?
Come on, Judge. Lawrence to the family of Buckner.
And Your Honor, at this time, I believe the people are still working on gathering some videos, so we are asking for an adjournment.
Man.
My apologies, Judge Crawford, on behalf of Tyler Cochran, filling in for attorney of record Bill Amadeo, with Mr. Cochran's permission. Is that correct?
Yes. Thank you, Judge. Did you say your name for the record?
Tyler Cochran.
Thank you, Judge. My apologies. At this time, we are, so Mr. Amadeo was very recently appointed, so we are just asking for a 2-week adjournment.
I can respond.
Probable cause conference will be adjourned to July 9th, 2026, 9 a.m. Esteban.
It's come to my attention that Mr. Cochran has made 5 attempts to contact the victim's number, along with talking to his brother, trying to get him to get her number as the effect her husband jail. So at this point, I'm going to be asking that his phone privileges be revoked.
Your Honor, this is my first time having this brought to my attention. I will talk to Mr. Cochran. I'll have they'll talk to Mr. Cochran about what no contact really means. I feel like at this point, we'll believe he'll get it. Get the message. I would just ask, Your Honor, I don't think having his higher phone privileges cut off is a pretty serious remedy. So we would ask, perhaps that just those particular numbers be, or her number be blocked.
Well, and certainly have a hearing to have him reinstated, but at this time, based on those representations, defendant's phone privileges are hereby ordered revoked.
Understood. Thank you, Judge. I'll
thank you. Court calls case people versus Brendan Lathrop.
Good afternoon, Your Honor. Good morning, Your Honor. Raymond Cook for the people.
Albert on behalf of Mr. Lathrop. Brandon, please state your name for the record.
Brendan Allen Lathrop.
In your today's date and time set for probable cause conference, we are asking that the matter be set for preliminary exam.
And discovery is complete.
To my knowledge.
People have their witnesses available the 7th.
Request, Your Honor.
Preliminary examination in person will be set July 7th, 2026, 9 a.m. before Judge
Freshour.
For Judge Freshour.
I'll be right.
Bond continued.
Judge.
Thank you, Your Honor.
Court calls case people versus Mohammed Dayan.
Morning, Your Honor. Raymond Cook for the people.
Albert on behalf of Mohammed Dian, Mohammed Lamine Dian, who's approaching the podium. Please state your name for the record.
Mohammed Lamine Dian.
All right, thank you.
And Your Honor, may we approach?
May.
Thank you, Judge.
and it was a great learning and eye-opening experience. I had no criminal record before this, and I will not ever be a criminal after this. Again, I am sorry for my actions which have led me here, and I learned a lifetime lesson. I'm sorry if this has any negative effect on the plaintiff. I didn't mean to cause any harm or stress of any kind to the plaintiff. Thank you, Tom.
I think what bothers me is that she made an initial report in January and you still kept contacting her, and she goes back at the end of March. She blocks you, according to her, from her phone. And then she's saying you use burner phones or different numbers to contact. She said you contacted her 200 times. They got you on a Ring camera, banging on her door. Now, she says this is after she told you to stop contact. So, I mean, I have some real concerns when I read this report, the pre-sentence and the police report today. I mean, I give you credit. You've been law-abiding. You granted an honorable discharge from the Army, correct?
The Air Force, sorry, yes.
The Air Force, I'm sorry. But you're jeopardizing what you have going on here by continuing to contact her. I mean, you got a pretty good job. You're going to have a pension over there, I'm sure.
Yes.
And I don't expect you to contact her at all. And some of these are scary. She described it as scary, but when you're saying, when she's telling me, or telling the police at least, not telling me, but in this, where she say, according to Susan Bryan, has left messages advising her that he is admirer of Hurok Park, which he knows Susan frequents. She sought therapy over the situation. Her email here does not appear to be vindictive to me in any way. I mean, I can just, my hope is not simply for punishment. I'm paraphrasing. I hope Brian receives the help, support through therapy he so much needs to address these issues. I'm not the first woman he's followed and harassed. I hope that this serves as a meaningful lesson and an opportunity for personal growth and positive change. My sincere hope is that Brian learns from this situation, heals and makes better choices and won't repeat this behavior toward another woman. So she sure doesn't sound vindictive to me. This isn't the situation that I see sometimes where a couple is divorcing and neither one of them feel that the other one deserves to breathe air on the planet. It doesn't seem like that's the case here. So I'm just telling you, I have real concerns here. I'm not going to order a GPS tether. I don't have any proof to substantiate that you were charged in other cases and convicted in other cases involving the same or similar type behavior. But I just want you to know, I'm not going to come across as threatening you, but if I find out there's any contact here, you're not going to like what I'm going to do. I'm going to place you on probation for a period of 12 months. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as direct. I'm going to order that you not have any contact with Susan Sherbrick. You cannot write, phone, see, text, email, or communicate with her or have anybody else do any of those things for you on your behalf. Sir, I'm going to order that you not possess any firearms or dangerous weapons. People in the military in the past usually have them. I'm going to order you surrender them to the Flat Rock Police Department. No firearms.
I surrendered them to someone else.
Who?
Yeah, I've met Carla before.
What's that?
I've met Carla before. She's been in my office. That's who you surrendered the guns to?
Yes.
She has, Steve wanted her to come up here and swear to that.
Where does she live? Where does she live, sir? Mr. Crane, does she live with you?
No.
Are you friends?
Yes.
How close to your house is she?
Mark. Wherever you want, Judge.
Yeah, I'm going to have you surrender him to the Flat Rock Police Department. Surrender to the Flat Rock Police Department. Make sure you call over there and tell him that's what I'm going to order. If you would, please, Heather, or whoever's done, surrender by end of day. And I want them to hold them during the pendency of this case. I'm going to order that you serve 5 days on the court work program. There's a $35 a day charge for that, for a total of $175. $100 fine, $100 cost, $75 victim's rights fee, $50 justice assessment, 3 1/4, screening fee 60 for 385, probation fees are 240 for 625. The total here with the court work program fees is $800. If you violate your probation, you could be revoked, you could be incarcerated for 90 days, you have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. I have to tell you, I actually contemplated ordering a GPS tether here. I don't want you being near that lady. If you're in the store, as an example, at Meyer, and you see her there, you're to leave your cart right where it is, and you're to walk out of the store. If you see her at Hurok Park, you're to leave your cart there, or I'm sorry, you're to leave there immediately. So no contact at all with Miss Sherbrooke, and you're not to go within. You don't live in a location within 2 miles of her, do you?
No, sir.
You're not to go within 2 miles of the victim's residence. I'm not going to order a tether of the victim's residence or place of employment. You understand that?
Yes, sir.
We'll give you a review hearing date. If you're compliant, you don't have to show up, counsel. He can just come and the case will be dismissed. If you're not compliant, you better hire your lawyer. You did a good job for you. Give me a date, if you would, Heather, in 12 months, so we can go early June, late May of 27.
Okay, that will be June 24th.
June 24th of 27 at 8:30 in the morning. And sir, can you pay all of this today, or do you need some time?
I need some time.
How much do you have today?
Okay, 500.
All right, we'll pay $500 today. I'll just let you pay $100 bi-weekly, and I'll start that beginning on July the 13th. Is that good? If you don't have the money at any point, no problem. Don't be alarmed. Call the court. We'll go on Zoom, or you can walk in here on before the due date, 8:30. Be glad to give you an extension. Just don't ignore me, okay?
Yes, sir.
All right, best of luck. Thanks, counsel.
Judge, I just want to state something beforehand. When you go to they always place this on the record. When you go to the police station,
the gun should be unloaded too.
And in the trunk. What I tell them is go in, but they come out.
Right, exactly.
That's right.
So that's what I'm, so apprise them. Tell me when you're going to go. You going to go today?
Yes, sir.
What time about?
Well, I live in Belleville,
so tell him he'll be there around 1. Is that good?
1 o'clock today.
Yes.
Or earlier or later?
1's fine.
1 o'clock. Tell them about 1, Heather, that Mr. Crane will be there, and he's not going to have any guns. He's not going to bring them in. He's going to go in and tell them. They're going to come out and they're going to confiscate the guns. Thank you very much. Have a good day. Thanks, counsel. And you'll meet with probation before you leave here. Alexis Smith, 26F264807807A.
Good morning, Your Honor. I'm Barrett, representing Alexis Smith.
Okay, good morning. Were you here at the initial hearing?
Yes.
Okay. Your name, ma'am?
Alexis Smith.
All right. She still hasn't taken care of this case out of Dearborn. Why not?
I don't know on yet.
You got a case out of Dearborn.
Yeah.
It's a civil infraction from 2015.
Okay.
Let me just check something here. I want to double check and make sure that's her.
They did meet with the prosecutor and we didn't flag any issues.
Well, no, because this was issued long before this case. But at any rate, I'm going to ask you to raise your right hand, Ms. Smith. You solemnly swear affirm under the penalties of perjury that the testimony you've given these proceedings will be the whole true self you got.
Yeah.
All right. Since you were in court on this back when I sentenced you on April 2nd, 26, have you been arrested?
No.
Any new charges?
No.
Any contact with the police?
No.
Okay. I don't want to, were you born in, yes, that is you. They're born. She should take care of that. Case dismissed, motion to prosecutor. She's compliant. And that is in 19th District Court in Dearborn, okay? So you should go there today. Good luck. We're all set. Have a good day. Thank you. Case dismissed. Gracie Sutton. Gracie Lynn Sutton, 26R514740. Your name? How you doing?
Okay.
You met with the detective Mercure, and you were going to plead responsible to impeding traffic. Is that true?
Yes.
All right, to that charge. So the charge with driving without due care and caution, you drove around a police vehicle? Where there was a car fire, is that right? You gotta be careful. To the charge impeding, responsible or not responsible? 0 points, won't go on your record. You plead responsible and not responsible. All right, I'm going to dismiss the original charge, $185. Cash your end of the hall to your right, okay? Have a good day. Mike Hicks. Is Michael Hicks, Judge Hessens, or mine? Heather? And I want to get this gentleman out of here.
I'm sorry, Judge, which one are you looking for?
Michael Hicks, 26F246193. Can you just check that out? Sir, wait 1 second. People against Anaya.
She's on the phone. I looked. That is Judge Hessen's case. I don't know how it got on your docket.
Hang on with us. Give me 1 second. Anaya Kenyatta Greer. Who do you have, counsel? 26F, 25F244382. What do you have?
This Caldwell?
All right, we'll search that one out. Where's Ms. Greer?
I'm here.
Oh, I'm sorry. Your name?
You're fine. Anaya Greer.
Hey, what's going on? This case was taken under section 771.1. That was back in October of 25. When I took the plea, I sent you October 16th of 25. All right, I never revoked her status. Raise your right hand, ma'am. You solemnly swear or affirm, I need to see it, please, that the testimony you'll give in these proceedings will be the whole truth, so help you God.
Yes.
Since you were in court when I sentenced you, have you been arrested?
No.
Any new charges?
No.
Any contact with the police?
No.
Case dismissed. Congratulations. Motion to the prosecutor. You're all set. Best of luck. We'll send you the discharge paperwork.
Perfect. Thank you.
Did you grab his, John? Do you have this lawyer's file?
It's up there.
Which one is it? Caldwell. Heather Barbara Maureen Caldwell, 26R514547. All right, good morning, counsel.
Good morning, Judge. My name is Alan Wood. My P number is 73076. I have this Caldwell and Fetish. All right, I represent her. Please state your name for the record.
All right, so she was arraigned on June the 11th. You pre-tried this today. She's going to plead guilty to operating while impaired, and the super drunk or operating while intoxicated high BAC will be dismissed. True?
No contest.
Why, was there an accident?
Lack of memory.
Would she blow on the breathalyzer or blood?
Blood was 0.19, I believe.
No accident?
There wasn't.
Oh, there was an accident.
Yes.
Was somebody hurt?
No,
Was it a one car accident or multiple?
one car.
Was anybody in her car with her?
No. Nobody was in the vehicle. She crashed into a railroad track.
You don't remember doing that? Okay. All right. So, I mean, I don't mind doing these when there's an accident and there's a possibility of civil litigation. I mean, if I get in the habit of taking everybody lack of memory, no contest on a 0.19 or higher, I'm going to have everybody coming up here and wanting to plead guilty. If you tell me as an officer of the court, you talked to her and she clearly doesn't remember, I'm going to go ahead and take that no contest plea. Is that what you're telling me?
Yes, Judge.
Okay, good enough.
They had to get a blood draw because I mean, she was.
Okay, good enough. So, ma'am, if you plead no contest, it has the same effect as a guilty plea. So if you plead no contest to operating while impaired, possible penalties are up to 300 fines, 93 days jail, 360 hours community service. Court costs are all 4 points. License suspension or revocation in accordance with your record, and your vehicle could be or might have to be immobilized depending upon your record. You understand all of that?
Yeah.
She didn't sign this advice of rights today. I'm going to need her to do that.
Yes, sir.
Take your time. Heather, who's in the waiting room there?
I'm not sure, Judge, if we could get them to identify.
Name, please. You have to unmute and tell me your name.
Robert Williamson.
Robert Williams. What is he here for, Heather?
He is here for a pretrial today.
Did we set him up with a lawyer before?
He did have Granada before.
So who's our lawyer today? Is it Mr. Granada?
Yes.
Yes, I will get him in a breakout room.
Perfect. Thank you. I just don't want the county having to wait for us. City, you mark that people's one. Counsel, do you stipulate that the clerk can use the police report to establish a factual basis?
Thank you, Your Honor.
Ma'am, have you now signed, read, and understood the advice of rights?
Yeah.
If you plead for no contest, you understand you're giving up all these rights and we're not going to have a hearing or a trial. Do you understand that? All right. To the charge, operating while impaired, how do you wish to plead? Okay.
No one.
Okay, I've had the report marked Peoples 1. I'm going to review it as soon as I get that marked and just to establish a factual basis. All right, based upon my review of the report, I find there's a factual basis for the plea. Ma'am, are you on probation or parole right now? Anybody force you to plead no contest? This is not on her. You never got printed on this, did you? No, I'm going to accept your plea of no contest. I'm going to dismiss the super drunk charge. I'm going to set new bond conditions. Heather, you need to print out an order for prints. Judge Kirsten was here in my stead and he ordered no alcohol, marijuana, or illegal drugs. And I'm going to continue that. I also do want you to go at this point to AANA. You are 26. Is that true? 36.
35.
35. Okay, sorry about that. I want you to go in AANA at least one time a week. No alcohol, no marijuana, no illegal drugs. You cannot leave the state. You cannot violate a law. You must appear in court as directed, okay? You also have to go over to the Rockwood Police Department to get fingerprinted and photographed by 1 p.m. today, okay? By 1 p.m. today. Today, June the 25th, 1 p.m. You have to go over there to get printed and photographed. We're going to send them an order that I'm going to sign. She's going to print out. And I'm ordering a screening and assessment. So here's what you're going to do. We're going to give you a sentence date. We're going to make sure it's good with you and your lawyer. And then you're going to go down the hall, get your sentencing date. You'll go across the hall to probation to fill out a question and be interviewed. And then you're going to go over to Rockwood to get printed and photographed. Okay. They're requesting cost of recovery of $250. This was a blood draw. I don't usually do that. I'm going to give $225 is all. I mean, I capped those at 150 on a breath and 225 on a blood. So we recognize there's more time involved. Do you have any questions, ma'am? Counsel, anything else right now?
No, Judge, thank you.
Let's give you the sentence date and make sure you're good.
July 23rd at 8:30.
Is that good with you?
Yes, sir.
Okay, July 23rd at 8:30 in the morning will be your sentencing date, ma'am. All right, so go down the hall, get your paper notice, and we're gonna give you a copy of the bond sheet as well. And then you go over to our questionnaire and then go over to Rockwood, okay? Nice having you here, counsel. Have a good day. Thank you. Skinner, Chrissy Eileen Skinner, 25W836-721A in 25B147863. Good morning. You're charged with failure to pay $362 on the 863 case. You're charged with failure to pay $249 on the 836-721A case. I'm going to arraign you on these. You also, it appears, have a clearance fee you have to pay on the no proof case. You're charged with is it fair to pay $249 or at this point is it $284, Heather?
$249, Judge.
You're charged with failure to pay $249. If I find you could have paid and didn't, you forget 60 days. Do you understand that? You're also charged on the civil infraction with failure to pay $282, is it? Or is it $317?
It is 317, 362 with the clearance.
So I'm going to bring you from failure to pay $317. You could get 32 days. Do you understand that?
Yes, sir.
Did you sign an advice of rights form here today?
I have not. I just walked in here willingly.
You're presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to question their witnesses, to bring in your own witnesses, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights and we're not going to have a hearing. Do you understand that? You have the right to a lawyer. I'd be glad to give you one at public expense if you want one. Would you like one?
Sure, yes.
Where have you been? Why didn't you come and talk to me like I told you to?
Don't live out here anymore.
I don't care. We got Zoom. You see all these people on Zoom?
I do. I patiently, I was okay to wait till last minute, or not last minute, but glad to see you today if needed, but.
What do you mean?
I don't live out here anymore. I got in a better situation.
Where do you live?
I live out in Northville now.
All right. Well, you don't live in Tuscaloosa, Alabama. I mean, come on.
I understand. I got out of that relationship. I got my head out of my butt and got a better job and.
You got to take care of obligations here, young lady. And it agitates me because I tell everybody, if you don't have the money to come and talk to me and you couldn't even give us the courtesy of a phone call and a Zoom call, I'll give you a lawyer. You get with the lawyer and we'll go from there, okay?
Okay, thank you.
I'm entering a not guilty for the record. Munoz, you can go right out in the hallway. Munoz. Joshua John Munoz. See on Zoom? 14B108400. B and A. So I'm supposed to. Your name?
Joshua John Munoz.
Where do you live, Mr. Munoz?
In Farwell, Michigan, sir.
I thought so. I remember this case. Because you know why I remember the case? Because it was so old. Because it was so old. It was a 2014 case. I'd like to go back to 2014 for at least a day or two. And I gave you time to pay and I told you to call me if you didn't have the money. You call me and talk to me about not having the money, or are you just showing up today and saying, hey, let's start over?
No, I'm not saying let's start over, sir.
Well, what are you doing? I mean, I need to know what you're doing. You know, $270 on this, allowing a licensed driver to drive. You didn't show up 11 years. You got a break. And then you owe on the other case $240. And you're late on these. And I told you what to do if you didn't have the money.
Your Honor, I had the $30 a month. I was under the impression that I could take the $30 a month and split it between the two tickets. And I don't know if the court recognized that I was going to be doing that because I believe that we
I
had.
said pay 30. Here's what I told you to do. On December 18 and 25, I said pay 30 per month beginning January 10. And then on the 14B, 108, 400B, count 2, the allowing the licensed driver to drive, I said pay 30 per month after fines costs paid on the A file, which is the civil infraction. Do our records reflect something differently, Heather?
Judge, it does. It looks like because he was paying on the web, so he's splitting his payments and doing 15 on each case. So it does, instead of doing it on one case, he was doing 15
Be up to
on
date? Would he be up? It's fine. Would he be up to date if he was doing that?
His last payment was done April 20th.
So this is June. How are you supporting yourself? I don't remember that. I remember that you didn't have a lot of money, which is why I went out of my way here.
I currently get Social Security disability. I get $728 a month, and it's very hard to try to survive on that.
Community service, Mr. Muniz, instead of this.
I really can't, Your Honor, because I just got diagnosed with cancer. I told you this was the last hearing, and I go in for surgery on July 23rd to have part of my foot removed, and they're going to take the cancer out. I'm not sure if I have to do chemo or radiation yet either.
Boy, I'm sorry to hear that.
Thank you, Your Honor. I do have $50 today on a debit card that I can please the court, hopefully, with a $50 payment. And I am so sorry for not allocating my money correctly and not paying you on time.
The fact that you were paying 15 each, that was an internal error. I will take responsibility for not being better at explaining to you. Here's what I'm going to do. I remember you had problems. I remember you had health problems now that you mentioned. I didn't remember that when I first saw you. You pay $50 today on 14B, 108-400B. I believe what you're telling me. I'm going to waive the rest of the fines on these, Heather. I don't see any reason to beat you down with this either. I'd rather you concentrate on your health.
Thank you, Your Honor.
I'll waive the fines and costs. You pay that on the B file, we're done. Okay, I'll waive the rest. Now, Heather, due to the circumstances, I don't think they like me doing this, but I'm going to waive the clearance fee too. So
Okay,
we're going to send you we're going to send the notice to the Secretary of State. So this suspension will be, which one did he have a clearance fee on again?
It looks like the B file has one. Actually, both files, Judge. I stand
We're
corrected.
going to waive the clearance fees on these.
Thank you, Your Honor.
So we're going to send you your clearances on these two. I don't know what your record looks like. Says you got a valid license. Why could he have a valid license? Or how could he if he had suspensions? But you got a valid license now, Mr. Muniz?
Yes, sir.
All right, well, good. That's what we're going to do. I'll go ahead and do that for you. I sincerely wish you well. Good luck. Take care of yourself. And I wish you well in recovering, okay? Best of luck to you. You're welcome.
Your Honor. God bless.
Paul, did I take Jan D. Paul? Jan D. Powell, 26R514722. I'm sorry, Miss Julie Powell. I haven't had the pleasure here a lot, and I didn't remember that you were the lawyer on this. My apologies.
No problem whatsoever, Your Honor. Julie Powell, P62448, appearing on behalf of the defendant, Jan Powell, who's president of court to my left.
Your name, ma'am?
Jan Powell.
All right, so that you negotiated this. It's going to be a plea to operating while impaired. The OWI super drunk charge will be dismissed. True?
Right.
If you plead to that, Ms. Powell, possible penalties are up to 300 fines, 93 days jail, 360 hours community service. Court costs are all those 4 points. license suspension or revocation in accordance with your record, and your vehicle could be, or might have to be immobilized depending upon your record. You understand that? And did, okay. Would you call over to Mr. Pellin, John, and tell him I need to make sure that these guys are signing advice of rights? I can't just rely on the previous one. Would you, counsel, would you have your client execute the advice of rights again, please?
I would, Rhonda, and I would indicate that I did discuss, her advice of rights with her,
Okay,
as well as, factual basis for her plea. She'll be reading about.
okay, no problem. Take your time in reading that. We're gonna wait right here, okay?
He said, he just not read stuff.
You don't need to put in your address or anything.
Yes.
All right, have you now had an opportunity to go over those rights?
Yes, Your Honor.
You've read them?
Yes,
You
sir.
understand them?
I do.
You understand you plead guilty, you're giving up all those rights, and we're not gonna have a hearing or a trial?
Yes, sir.
All right, to the charge of operating while visibly impaired, how do you wish to plead?
Guilty.
Were you operating a motor vehicle on May the 2nd of 26 at 9:08 PM at or near 32823 4th Street in the city of Rock?
Yes, sir.
What business is that?
It's a Dollar General.
And did you drink alcohol prior to operating that vehicle?
Yes, sir.
What and how much?
Okay.
How much?
Not sure, sir.
Well, were you drinking at a bar? Were you drinking at home?
No, actually, in the parking lot of the Dollar General.
Okay. And was your ability to operate, did the police just come on the scene then and see?
Sorry to interrupt you. A woman was concerned. Sorry, I was asleep in the car. I didn't want to drive. I'm only like 2 miles from there. And I was gonna have my boyfriend come pick me up, but she was concerned about me, so she called the police.
And you were, at the time, was the vehicle running?
No, it was not.
Your Honor, if I may, when the police arrived at the scene, did we attempt to drive the vehicle out of the parking lot?
Yes, then.
Okay. And ultimately you were arrested and transported to the police station, true?
Correct.
Was this a blood draw or breathalyzer?
Breathalyzer.
And were the results, counsel?
I believe it was 0.18 and 0.19, Your Honor.
All right, and you stipulate that those were accurate readings for purposes of the plea?
I do, Your Honor.
Ma'am, are you on probation or parole?
No, sir.
Anybody force you to plead guilty to operating while impaired?
No, Your Honor.
I'll accept the plea. I'm going to dismiss the super drunk, refer you for a screening and assessment. And we'll give you a sentence date. Has she been going to AA one time per week?
No. Like a fireman done that whole.
Wait a minute. Did I not order you to go once a week? May 28th?
I didn't know I was supposed to start that till the sentencing.
We didn't even have a conviction. You were supposed to start.
I found one in the church right by my house that
You got to get going. You were supposed to start that day.
I wasn't aware of that, Your Honor.
Am I doing that bad where I'm not conveying that adequately? Give me a sentencing date, Heather, please.
July 23rd at 8:30.
Is that good with you, counsel?
It is, Your Honor.
What is the relationship between you two?
The defendant is my sister.
Okay, okay. All right. Good luck. We'll see you here. You're going to go down the hall, get your notice, and then you're going over to probation where you're going to fill out a question and be interviewed, okay?
Okay, thank you, Your Honor.
Thank you very much. Good luck. Michael Darrell Hicks.
Yes, sir.
I'll just take it, John, Heather. 26F246193. So I'll just, is this Judge Hessen's Flat Rock docket? Come on up here, sir.
Thank you, sir.
I'll cover that with them in a second. And I'm going to need Mr. Granata to tell me the case he's on there. Tell John, would you, Mr. Granata? You're charged with driving on a suspended. You have the right to an attorney. If you want one, I will provide you with one. Would you like one?
Yes, please.
All right, we're going to give you a lawyer. I'll just take this one. It's my Flat Rock docket today, isn't it, Lisa and Heather? You're all set.
Yes, Judge, this is Judge Hessen's.
I know. Whose Flat Rock docket is it?
It is hers, or I'm sorry, it's ours today. I'm sorry, ours.
I'll just handle this case, unless you want to go to Judge Hessen. If you do, you're not going to hurt my feelings.
No, Judge.
Okay.
I also wanted to say, I do believe I thought I already had reinstated my license.
Okay, you tell your lawyer that.
Okay.
Okay?
Okay, thank you.
Go right outside the prosecutor's room there, and we'll bring this out, and we'll give you a lawyer, okay?
Thank you so much.
Thank you.
Great day, sir.
Brian, which one do you have?
Mr. Williamson and Miss Montes.
Robert Eugene Williamson, 26F245827 A and B.
P78413, MIDC counsel for Mr. Williamson.
Sir, your name?
Robert Eugene Williamson III.
All right, so we have an operating with the presence of drugs, and we have a resist, hinder, and obstruct an officer. Something must have bothered me if I set a bond like I did. That at any rate, he's going to plead guilty to operating while visibly impaired. The prosecutor then will move to dismiss due to the consumption of drugs. The prosecutor will move to dismiss the operating with the presence of drugs and the resist, hinder, and obstruct. True?
Yes, sir.
If you plead guilty here, sir, to that charge of operating while visibly impaired due to the consumption of drugs, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service. Court costs are all 4 points. License suspension or revocation in accordance with your record, and your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
Yes, I do.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to a trial by court or jury. You have the right to question their witnesses, to bring in your own witnesses, to use the subpoena powers of the court to bring in those witnesses and to testify if you so choose, or remain silent. If you remain silent, the jury would be instructed that they cannot hold that against you. You do, however, have the right to testify also at a trial. If you plead guilty, you're giving up all those rights and you're giving up your constitutional right to a jury trial. Do you understand that?
Yes, I do.
You still wish to plead guilty?
Yes. Yes.
To the charge operating while impaired due to the consumption of drugs, how do you plead?
Guilty.
Were you operating a motor vehicle on Telegraph near Ypsilanti and Flat Rock, February 5 of 26 at 1:59 p.m.?
Yes.
Prior to that, did you ingest, consume some drugs, including methamphetamines? Is that true?
Yes, I stored a lot.
And you were under the influence of that at the time you were operating the vehicle, correct?
Yes. Yes.
Why were you pulled over by the police? What were you doing wrong in your operation of the vehicle? I mean, were you swerving, speeding?
Improper lane change, and they had a report from, I believe, the gas station that he was at about a rack.
All right. And so how did he, what did he do then?
He basically pulled out of the gas station and not into the proper lane. You're supposed to pull into the right-hand lane. He pulled into the next lane over. That was one of the reasons of reasonable suspicion. There were other things in the report. There was one other thing in the report that led them to pull him over.
Did you do that, sir? Pull into the wrong lane like your lawyer just described?
Yes, I did.
And counsel, you stipulate the toxicology report reflects the presence of these.
Yes, I spoke to Mr. Williamson. I did review the results with him, and he does not contest it.
Are you on probation or parole, Mr. Williamson?
No.
Anybody forced to plead guilty?
No.
Please accept it that impaired due to consumption of drugs. Resistant obstructs dismissed. The OWPD is dismissed. I'm going to refer you for a screening and assessment. Are we going to do this on the 23rd again, Heather?
This one we can do on Tuesday, the 14th.
July 14th at 8:30 in the morning will be your.
Judge, this one's our afternoon docket, so we could do this one at 1 p.m.
At 1 p.m., sir. July the 14th. July the 14th at 1 p.m. So probation is going to be notified. They're going to go on there. They're going to talk to you. And we'll go from there, okay?
Okay. I will be back in court on the 14th.
Good.
You had asked the court to release Mr. Williamson.
Well, something bothered me here.
Yeah.
Your name?
There was if I could explain.
Okay, well, wait a minute. Let me get his name.
Morning, Your Honor.
I don't know if you need to review this or not, but I don't set 40,000. How many priors do you have?
I saw it on YouTube. There was a problem, Your Honor, when he was having some arraignment. He could not hear. There was something going glitching on his end as far as the Zoom.
I didn't.
Kept seeing other, and he was basically irate about the fact that he couldn't hear the proceedings and that he made some unfortunate comments.
What kind of comments?
I think he used the F-bomb at some.
You didn't do that, did you, Mr. Williamson? You know you're in a courtroom. You're not at a strip club. You know that.
He wasn't directing it at you, Judge, but he was.
He wasn't directing it at me. He was talking to me, wasn't
I
he?
understand. He was in your courtroom.
He wasn't directing it at me, though.
I mean, he didn't. I take that back. He used the F-bomb in your courtroom, and that's.
It's not my courtroom, but thank you for the compliment. Listen.
I wasn't present for that, so I'm not aware of any bad behavior by this defendant. I will leave it to the court's discretion regarding my.
Let me see what he's got here. He's got a bad record, huh?
13 years old, though. I haven't been in trouble in 13 years in Michigan. I can
You
change my
made
life.
up for it by what you did your first few years as an adult. I'll tell you that.
That's true.
You get,
But I
I'm
paid
sorry?
for it. I said, that's true. I went to prison for it and everything. I paid
not
for my.
shocked. The system would be a complete failure if you hadn't. Wait 1 second. Let me double check something here. There's printed on June the 8th. I see. We got the offense date wrong on the CCH. It should be February 5th. Okay. You live on Adams Street, Monroe?
Yes.
Yeah. Well, you want to sell pretty well.
What kind of bonds conditions did I set? Did I set bond conditions on this, Heather? I should have.
I'm going to look right now, Judge.
Here they are. I was gonna say, I didn't think I'd get that flustered by somebody screaming at me.
I got it.
All right. Where does he work at?
Your Honor, he is disabled. He has PTSD. He has not worked in several years.
Is he on disability?
Yes, not fixed income SSI. Disability.
And he lives on Adams?
That's right.
Who do you live with on Adams?
I live by myself. My mom lives above me and I take care of her because she's dying right now. I live at 311 Adams and she lives at 311 and a half Adams right above me in an apartment building. And I pay my own rent and everything, so $725 a month.
What can you post here?
I'm sorry, I didn't hear you.
How much money can you post? I can lower the bond, but I'm not going to give you a personal bond.
Okay, well, then I'm not going to accept the plea.
I already took your.
I'm not going to accept the plea if you don't let me out. I mean, I just, that's, yeah, I'm not going to accept the plea then. Yeah, I just rebuke the plea and we'll just do the whole time and then I'll just put you in civil court. Because I believe you took the.
You want to get belligerent with me, Mr. Williamson?
I'm not getting belligerent with you, sir. You're getting belligerent with me. I want to get out. And I didn't
Well,
do
good. I
it.
wanted to be the president. Some things don't work out. I'm telling you, don't.
Well, then I refuse. I
Crappy with
refuse.
me. You
Okay,
got
then
it?
I refuse.
I'm looking
Then I
for a
refuse.
way to pull you, get you out of there, but you're not going to
I don't have
negotiate.
any money for bond. I don't have any money for bond, Your Honor. That's all it is. That's the only
We
problem.
can set it for a jury trial in another month if you want. I can do that for you,
That's
keep the
fine.
bond in effect.
That'll be fine. We'll go for a jury trial in a month then. All right. Because you took a blood test from me on the 8th and you arrested me on the 5th.
I didn't
So I really-
arrest anybody. I'm not a police officer.
But I just want to get out and go home to my mom. and
I
mom's
don't care
dying.
what you want. I'm going to tell you right now, I don't care what you want. There was a reason I set this bond, and it wasn't just because you got belligerent with me. I'm trying to figure out a way to release you, but I am not giving you a personal bond. You don't deserve a personal bond. You hadn't shown up on the case. You got a prior, and you got multiple felony charges and convictions. So please, don't act like an angel with me.
All right. I refuse to plead then. We'll go to jury.
You want to talk to him?
I do, Your Honor, if I.
We'll put you back in a breakout room. I was looking to reduce the bond. I'm not giving him a personal bond.
Your Honor, could I, do you have a?
I'm not gonna negotiate with anybody here.
Still already though, does that
Mr.
matter?
Williamson, I'm talking to your lawyer right now. You are
Okay.
not helping yourself.
Sorry about that.
You don't want to get out. You wanted to get out. Well, maybe you should have thought about that before you started swearing at me.
I didn't mean to swear at you. I apologize. I didn't even know he was in court. My screen was messed up. I'm being honest with you.
Your Honor, if I could have 5 minutes, that's all.
We'll send you in a breakout,
All right.
okay? And as of now, I have accepted his plea,
I understand, Judge.
okay? Brian Scott Martin, 26F246-469. Your name? All right, you're charged with drive while license not valid. You have the right, you have a lawyer, you have the right to a lawyer. If you want one, I'll give you one. If you want a lawyer, I'll go ahead and arraign you and I'll send you to the prosecutor. Fair enough? It is alleged that you did on June the 11th of 26 operate a motor vehicle without a valid license that is a misdemeanor punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that? You just sign, read, and understand the advice of rights. You plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that? You still wish to waive your right to a lawyer? Not guilty, please entered. Personal bond 500. We'll take you to the Flat Rock prosecutor. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'm sure he'll be reasonable with you, and we'll go from there. I still need these guys. You got to remind them, John.
Yeah, see,
They're not having them sign advice of rights. I'm going to have somebody sign the Montez advice of rights, and I will come back. You go out in the hallway and he'll set you up with the prosecutor. Who's Rebecca Montez? John?
Yes.
You remind Roger too to do that. I'll take a 5-minute recess. She needs this. What's the rights? This is going to be,
Thank you.
recalling Robert Eugene Williamson. This
I've
is-
got to get him out of the breakout room, Judge. He's still in there. Let me get him out.
Problem. Recalling Robert Eugene Williamson, 26F245-827A and B.
Good morning, Your Honor. Peter Bernal, P78403, MIDC counsel. Your Honor, I
Try
tried.
your name again. You have to unmute. State your name. You have to unmute and state your name.
Robert Eugene Williamson III.
Okay, go ahead.
Unfortunately, there's been a breakdown in the relationship. I was not able to get through to Mr. Williamson about some of the points of law regarding his case. And at some point, he said that he would prefer to represent himself going forward. So I would ask the court to withdraw.
I want you to know, Mr. Williamson, there's no basis in law to plead guilty to something. And that before we go on, just relax. Just relax. Listen to what I'm going to tell you so you don't hurt yourself further. There's no basis in law to tender a guilty plea. Ask your lawyer to file a motion or orally argue a motion to reduce the bond. Have the judge deny it and then say you want to withdraw your plea. That's just not how the system's going to work. Now, I'll be glad to let you file a motion to withdraw your plea if you choose to represent yourself. I'd strongly advise you against discharging Mr. Granada. Sometimes lawyers are a little bit like doctors. They have to tell people, clients, or in doctors' cases, patients, things that they don't want to hear. But see, you don't have any schooling in this. You're making a big mistake if you choose to discharge him.
I don't want to discharge.
You, just listen to what I'm going to tell you. I was reminded as to how vile your conduct was on the break. That being said, I'm talking about the arraignment. That being said, I'm going to overlook that. I'm going to be a lot more fair with you than you have with the system, not with me. Not with me. I don't know why you're so angry with the system. There's no basis for you to be angry with the system. If you were convicted of all these felonies, well, then you committed them, period, plain simple. So if you want to discharge Mr. Granada, you want to have that conversation, that's fine. You can move.
I don't want to discharge Mr. Granada.
Your Honor.
I just can't afford bond. That's all.
Mr. Williamson, it's a different conversation. That's a different conversation. You don't get to decide what the bond is. You should have thought about that when you were throwing around F-bombs at the time of the arraignment and when you didn't show up on this case and when you accumulated a record.
Well, I would like to go to trial. Is that okay?
Unfortunately, I have accepted your guilty plea already. And now you're going to have to find a legal basis to ask me to set aside the plea.
Okay.
And I'll be happy to entertain that.
I can do that now. The legal basis is that he told me that I would get time served today if I accepted the plea. And that's not the case.
Hang on a second.
Your Honor, I explained that because it was a drug-related case, that he had to report to probation. And that this wasn't over until after that interview had taken place and at the sentencing hearing.
Mr. Granada's been around. I don't believe he would tell you that. Okay? He didn't tell you were getting time served because he knows, and I know, and anybody who's been out of law school for a day knows, I have to, by law, order a screening and assessment on a drug or drunk driving. It's not my rules. You can argue with this legislature if you want to. So he would never have told you that.
I did explain to Mr. Williamson.
Well, it should be on video. If you look at the video, you see I'm telling the truth.
Mr. Williamson.
I did explain to Mr. Williamson that in your discretion, that you would be able to
reduce the bond if I wanted to.
Well, that you would be, when it came to the penalty phase.
Of course I could.
That you could give him.
Of course I will. It's not discretion. Of course I will give him credit for every day served. It doesn't mean that's going to be the extent of the sentence. It doesn't mean it won't be the extent of the sentence. So I'm trying to tell you here, I have, and by the way, I was trying to help you.
Okay.
I was not, even though you acted like a child who has an anger problem, when you were at the arraignment in Flat Rock, I was reminded by my staff. And I mean, you ought to be embarrassed for yourself. But even though that occurred, I'm still going to be fair with you. But I'm not going to bend over and let you change the rules or dictate to me or dictate to the system how the system's going to handle the case. It's not happening.
Okay.
Now, I accepted your plea.
Okay.
Period.
Okay.
I'm going to order a screening and assessment.
Okay,
Probation's gonna come in here and interview. I will give you an early sentencing date when Mr. Granada is here. If you choose to move to withdraw the plea in the meantime, I will be happy to entertain that, but you're gonna have to do it in writing through your lawyer. If you want me to discharge Mr. Granada and you want to draft the pleading, which I would find to be a complete impossibility for you to do on your own, I'll entertain that motion verbally right now. He told me he wanted to withdraw. He thought there was a breakdown. You said you don't want him to withdraw. Do you or don't you want him to withdraw?
no, I don't.
Okay. So I will give you an early sentencing date.
Okay,
I will, on my own accord, reduce the bond, not from a 40,000, 10% to a personal. I will reduce it, whether he can post it or not, to 10,000, 10% post, 10,000, 10% bond. So if you can come up with $1,000, you will be released. Otherwise, you'll appear for a sentencing date, and we're going to do it soon. So
Okay.
I will be a lot more fair with you than you have been with the system. You're good with that, right?
I'm good with that.
Because if I wasn't going to be more fair with you than you have been with the sentencing, I'd keep the bond in effect and I'd set your sentencing for the end of August. I'm not going to do that, no matter how belligerent or no matter how belligerent you are or some other defendants that hate the country are. Okay. And
Okay,
threaten to sue and all this stuff. Feel free.
thank you.
Feel free. Give me an early sentencing date. The
Thank you
earliest
for your
can give me.
generosity.
Okay, Judge. So it doesn't need to be on a flat rock day, correct?
No, there was no accident here. I could do this early next week.
Is Mr. Granada here on Thursday, on the 2nd?
What's that?
Mr. Granada, are you here on July 2nd?
Why don't we try to move it to Tuesday
Oh, yeah.
or Wednesday?
Oh, Tuesday, okay. I don't think we have Mr. Granada here though, do we?
Let me check. I'm looking at my calendar right now.
I'm looking at the calendar too, July.
Okay.
I don't have you Tuesday. I don't have you on Tuesday or Monday. The soonest I'm seeing you on the calendar is Thursday, the 2nd.
Yeah, that's what I'm showing. Thursday the 2nd is my next time before the. I do have.
You have subsidiary?
I can come in on the 29th or the 3rd.
Can you do it the 30th by Zoom? Can we get in trouble with MIDC by having him do that one
Only if
case?
there's no overlap. I'm in 34th from 8 to 11. So if we could do it after 11, then I'm good.
I don't have a problem with that. Can you be here by 11:30, do you think, or not?
From Romulus?
Or do you want to do it at 1?
Can we do it at 1?
At 1 o'clock, June 30th is when I'll send you. You're going to wait and probation's going to come and talk to you. If you somehow post your $1,000, you'll be released. And anyway, your sentencing will be Tuesday at 1 o'clock. Good luck. Bonds continue. Thank you.
I'll put you in a break.
Montez.
Mr. Williamson, you have to wait. I got to put you in a breakout room. You're going to meet with probation.
I got to get
appreciate
these
that.
signed. The advice of rights for some reason are not getting signed today. Maybe they've happened out of Rockwood, but I had to hand her this one. Did you sign the advice of rights now, Ms. Montez? John, you gave it to her, right?
It's also on the back of the plea forms, Judge.
Yeah, I know.
I went over with verbally.
When they check in at the front,
But not when there's a pretrial. When there's a pretrial, they don't have to sign an advice of rights unless there's a plea. So do you have that in front of you right now, Ms. Montez?
Yeah.
Okay. Well, I asked him to give it to you. And did you read that yet? Is that a yes? Is that a yes?
Yes.
You can't speak with mhms or ahs, okay?
Yes.
You sure you read it?
Yes.
I'm going to call the case, and then and you have to remember, you can't or nod your head. Rebecca Ann Montez, 260-246-402. Your name, ma'am?
Rebecca Montez.
Peter Bernard, P78413, MIDC counsel for this matter.
Now you can hand up the advice of rights. I don't remember what the plea was. Okay, so there's been a resolution reached, right, Mr.
Yes, sir.
Zanana? And what are the terms of that?
Your Honor, Ms. Montez is going to plead guilty to personal responsibility under the delayed sentencing 771.1.
Is that what you want to do?
Yes, sir.
If you plead guilty here, possible penalties are up to 500 fines, 90 days jail. Costs are all those. I'll take it under section 771.1. I'll set terms and conditions, and if you're compliant, I'll dismiss your case. Understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes.
And the prosecutor will actually be the one to dismiss, move to dismiss. You understand that?
Yes.
You understand if you plead guilty, you're giving up all the rights and there's not going to be a trial?
Yes.
Do you have any questions for me before I ask you how you plead?
No.
To the charge violation of parental responsibility law, how do you plead? Did you allow a driver to operate a motor vehicle that was unlicensed on Atlantis 29867 Atlantis Drive in Flat Rock on May 26 and 26?
Yes, Your Honor.
Was that your child?
Yes.
And he's 15?
Yes.
Is it a he or she?
He.
Were you in the car?
No.
You let him drive the car without anybody? Who was in the car?
Your Honor, if I may, he, because the parents weren't home, he found the keys and took the car and.
How can she be convicted of allowing an unlicensed driver?
They can't
Ma'am,
drive the car.
ma'am.
Sorry.
Your Honor, he did not have.
Hang on a second. Had your client, I'm sorry, had your son ever driven that car in the past?
No.
Did you give him permission to operate the motor vehicle on that day?
No.
Did you know that he was going to drive the motor vehicle on that day?
No.
How can they prove their case if she didn't know him?
Your Honor, they have, the police officers have a video from one of the people he was playing basketball with of that vehicle in that parking lot. And there would be no other explanation to how it got there other than he drove it there.
Yeah, but what if he grabbed the keys? If what she's telling me is true, I mean, I suppose she could file a complaint against her son for theft of the automobile.
Your Honor, if I could tell you a little bit about him, this has never happened before.
No, you don't have to tell me. I don't have a factual basis for a plea here. She has to knowingly allow somebody to operate that motor vehicle. She did. I'm not saying what she's telling me, by the way, Ms. Montez. I'm not telling you, saying that you're not guilty of this offense. So let me be clear about this. I can only accept a guilty plea if somebody's telling me facts that can lead me or any other judge to reasonably conclude that you're guilty of the offense as charged. Now, some people want to come and tell me that they were in Tuscaloosa or wherever else at the time of the offense, and maybe they were, maybe they weren't. But if don't take me as saying I'm going to find you not guilty by virtue of this conversation. I'm only telling you and your lawyer that based upon the words that are exiting your mouth, there is not enough for me to be able to establish that you knowing allowed your son to operate the motor vehicle. Now, I know what I would do if it was my son that if I had a 15-year-old at the time that took my car, he'd only be in the house for about 2 months. He'd only be writing about 50,000 times. I will never take a motor vehicle that belongs to my mother or father without my permission. That's what my dad used to do to me. I used to think it was ridiculous, but really it wasn't. So if this was not like that, but
Your Honor, this is the prosecutor.
What's that?
Your Honor, this is Roger Kelly on behalf of the City of Flat Rock. This is not an allowing an unlicensed driver to drive case. It's a parental responsibility case, failure to supervise.
Well, wait a second. It's still, you want to come in here? I can't convict somebody of any criminal offense. I'm only reading off the ticket. Allowed an unlicensed juvenile to operate a motor vehicle. That doesn't, come on in here. Let me
I'll be right there.
explain. Let me explain. Come on in.
Thank you.
I'm only explaining, even a violation of the parental responsibility law. If I go out with my wife and I have a 15-year-old and if he grabs the keys and takes the car without my permission.
Well, I didn't hear the explanation, Judge.
Well, here's what she's saying. She didn't know that he was going to drive the car. She'd never allowed him to drive it before. She didn't give him permission to drive it that day. he took the keys and started to drive. Now, like I just was trying to explain to her, you know, as you know, and as Mr. Granata knows, some people want to come up here and tell me they were, you know, a choir boy and they didn't do anything wrong. And then it turns out maybe they did. So I don't know if this is one of those cases or not. I'm just trying to explain to her, I cannot take a plea to a guilty, to a crime where somebody's kid takes keys, if he did that, underline it, bold it, put it in big letters, without their permission and decided to drive the car. Now, I know what would have happened, and I explained that too. If I had never done that. Okay? So, I mean, I'm just telling you, that wouldn't have been something I even thought about, let alone dreamed about. But what, 15. I mean, I'm just saying, if my wife and I have a 15-year-old, we leave the house and takes the keys without any knowledge or permission of us, no court in the land should convict us of anything. No court in the land should convict us of anything.
Your Honor, if I could have like 5.
Yeah, I know. I can tell that things are toning down here based on our conversation. I have a feeling. And, you know, that's something that you're going to get to deal with. I can tell things are toning down. Sometimes people, as you know, they're not experienced. They come in, they're going to tell the judge whatever they want. And I'm not saying you're doing this, but I have to do a job here, and I'm going to do it. So you guys go talk, figure it out. If you want to go to trial, we will. If you want to look at it again and say, maybe they shouldn't issue a citation, that's fine. You can, whatever you want to do. I'm just telling you, I can't take a plea based on the words that come out of her mouth.
All right, thank you.
Okay?
Right.
Thanks.
I'll make it, Mr. Keeley. I do have one other case. If you could.
Which one's that? Kennard?
Webb, it's a sentence for Mr. The dog, right?
Yeah. Andrew Webb. Do we have those parties out there at 10, by the way?
Yes, Judge.
Would you ask them, tell them I got to do one sentencing and I will be right with them and give them my apology. Andrew Joseph Ellis Webb, 26B 824-020A. All right. Name?
Andrew Webb. Peter Granata, P7143, and my DC counsel for Mr. Webb.
So they're not going to seek restitution. I just want to make sure that we do not have a Danielle Stetzinger here. Where is the dog now? So just for the record, he pled no contest, possibility of civil litigation under section 771.1. What kind of dog is this again?
American Bulldog.
Where's the dog now?
He's still at my residence.
Nobody showed on this, right, Lisa or Heather?
Not on Zoom, Judge.
All right.
I talked to probation. They made contact with the alleged victim, and they are not interested in.
I want to make sure this doesn't happen again. I didn't like these looks of these photographs. It's a dangerous dog you got.
Very large.
Well, I mean, you got an obligation to keep the dog in the house. I mean, it's nice that people want dogs. I like dogs. That's great. But we got to control the dogs. This could have been a lot worse.
I explained that to Mr. Webb. He understands that the law is very strict when it comes to control of that animal. Again, it's going to throw himself on the mercy of the court as far as regarding sentencing. I would like to speak to a little bit about Mr.
You know, if this happens again, sir, they're going to ask me to destroy that dog. You understand what I'm telling you? And I mean, did you see the pictures?
Yes.
I mean, they're not pretty. Black and white are okay to look at, not the color.
Well, at least some of those injuries may have been caused by his claws as opposed to the fight.
I don't care how it happened. Go ahead. Tell me what you want to say.
Judge, Mr. Webb is currently, he's in the concrete business. He does independent contracting right now. He does work mostly for a concrete company, local company. He's laid off from that right now. There's a new project coming up, but right now he's having some financial hardship. He's single. He's got 3 children that he's financially responsible for. He's a high school graduate from Taylor Truman, and we would ask the court to consider that and pass the sentence. I believe he has the ability to pay some today, but depending on the amount of fines and costs that he might be allowed to be in front of payment line.
You have a dog, you have fenced in yard?
Yeah.
So I want you to understand, what else do you want to say? Anything else, Mr. Bernardo?
Sure.
How old are your children, sir?
11, not 12.
Well, I worry about them.
It's wonderful. Children. He loves it a lot.
Well, that's good, but I want to make sure that you understand one of the orders I'm going to give, but I'm going to expect full compliance with. I don't want to threaten you. I worry about these kinds of things. People get hurt. You see enough on TV, people get mauled to death. I'm not saying your dog would do that, but this is bad enough. 12 months probation. I'll take it under 771.1. You cannot leave the state. How'd the dog get out, by the way?
Jump fence, I think. I don't know.
Well, that isn't good.
The neighbor's dog, they all play together.
Look here.
Listen
to me. Listen to me. I don't care what you got to do. If you got to have the dog on a leash while in the backyard, tied to a tree. That scares the devil out of me. So it's up to you to fix that. So your dog is to remain in a fenced-in yard where he's incapable of getting out of the yard without an adult allowing him, unlocking fences, etc., opening fences, etc., or in your home, or on a leash, accompanied by you and equipped with a muzzle. So that dog gets out of there, I'm telling you, I'm not going to be nice. So 12 months probation, you cannot leave the state, cannot violate a law. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed your dogs to remain in the fenced-in yard, your home, or on a leash accompanied by the owner and equipped with a muzzle. Equipped with a muzzle. Restitution, if any, per the everything, all indications here, is to be handled through civil litigation. I hope you're going to take me serious because I get it, but I don't get it. You got to make sure that dog stays in there. Restitution to be handled through civil litigation, fines 100, costs 175, victims' rights $50, justice assessment. Probation fees are $240 for a total of $565. I'll give you a review hearing date. If you're compliant at the end of the year, case will be dismissed on motion to prosecute. What do you have, Lisa? Or Heather?
This will be, let me take a look here, Judge, because this looks like a Brownstown case.
Yeah.
So it'll be June 23rd, I believe, but let me double check that 27. Yeah, June 23rd.
At 8:30. Now, how much of this can you pay today?
It's 500
65.
300.
300 now, and I'll just give you till July the 20th to pay the rest. Can you do that? And if you need more time.
I can pay the whole thing today. I actually have that in my truck.
Okay. You'll pay that, you'll meet with probation. I don't usually do this. I almost ordered community service on this one. Make sure that dog stays there. Thank you. Stephen Kennard, I need everybody here to, I'm sorry, I'm going to conduct a settlement conference. We're going to go off Zoom, John, right now. And I am going to conduct a settlement conference. I'm going to ask everybody to leave the courtroom. This is unrelated to any court proceedings.
Said this started with him turning himself in. We'd ask the court to release him to reduce his bond or to something minimal, or to release him on a PR bond with a scram tether. That would allow him to continue working while we're dealing with this matter and help with his family. Like I said, this matter, while there's a failure to appear, I believe that this his reclamation started with him turning himself in on April 28th at the Macomb County Jail.
Based on the notes that I'm seeing, it looks like back on June 8th of 2023, the defendant failed to appear for a PCC The next PCC was not until August 8th of 2024, so over a year later, they had to appear in custody from Wayne County. The defendant then also failed to appear, I believe, 2 more times. One of those I will attribute to the defendant potentially being in custody in, I think it was Macomb County. But the third one was the defendant failing to appear for an exam on October 29th of 2024. Given the multiple failures to appear, I have concerns that this defendant would not show up for future hearings. And I would ask
So it was set for exam and he failed to appear.
on October 29th of 2024 for my notes.
But the motion for bond reduction denied, bond will continue.
Thank you, Your Honor.
Court calls case People versus Malachi Beverly, AKA Malachi. There he is, I think. Go ahead.
Your Honor, Amy Lucas requesting permission to practice under Michigan Court Rules 8.120 under Assistant Public Defender Bellinger.
Oh, you got it. Permission to practice is granted.
Thank you. On behalf of Malachi Beverly, we are seeking an adjournment on the matter. You can offer, and we need time to file the paperwork.
Okay.
Oh, you say your name.
Okay, no, go ahead, start again. No, you just, it was like I let you go. I was gonna like, slow down, young pup, but you just go ahead. All right, you realized it, right? Okay, go ahead, correct yourself.
Okay, could you please state your name?
Sir, can you state your name?
Malachi Beverly.
All right.
Okay, we're seeking an adjournment on the matter. Just you can offer, we need time to file the paperwork.
Oh, you need time just to file the paperwork. All right. Why don't we do July 9th? 2026, 9 a.m. Did you say that sounds good?
Yep.
Like, did I seem to? Well, never mind. All right. That's the day we'll do. Bond will continue. Thank you, Mr. Beverly.
Thank you.
Court calls the case People versus Gary Thomas.
Excuse me. Stephanie Cannon on behalf of Mr. Thomas, who is approaching. Mr. Thomas, could you please state your name for the record?
Gary Thomas. Thank you.
And Your Honor, we're just asking that this case be set for a preliminary exam.
Right. Discovery is complete.
Yes, to the best of my knowledge.
First, 911 call yesterday, Your Honor. The defendant does have another case that's set for its first court judgment. Did set this exam for that same day where it's flagged. So another child use case with the same victim. I don't see why.
If I set it for the same date, you say? You have any problem with that?
No, Your Honor, 721 is far enough out. I believe we'll be able to get that discovery by then. Yes.
What'd you say?
No, Your Honor, I have no problem with that.
Preliminary examination in this matter will be set July 21st, 2026, 9 a.m. before Judge Moore. Bond will continue.
Thank you so much.
Court calls case People versus Richard Bauer.
Assistant Public Defender Davi Lieb on behalf of Mr. Bauer, who I've not been able to speak to.
Not checking. He has a community corrections bench warrant for no bond in any event in this case. So we will continue the community corrections bench warrant.
Thank you, Your Honor.
Court does call the case People versus Devon Thompson.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Marcia Courage on behalf of Mr. Thompson, who's approaching.
Devon Thompson.
All right.
I was just appointed on this case, Your Honor. I do not have discovery, therefore I'm asking for an adjournment in this matter.
During the matter to July 9th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Court calls case People versus Maurice Boyd.
Things are not for the people, Your Honor.
All right, Maurice Deshaun Boyd.
Thank you.
Oh, great. Michael Gaddy, Assistant Public Defender for Mr. Boyd, Your Honor. Your Honor, we're asking for an adjournment to see if we can't negotiate a settlement here or in court in county.
During the matter to July 16th, 2026, 9 a.m. Bond continued.
Thank you.
God bless.
Thank you, sir. Court calls case People versus Joseph Thompson.
Edward
Rodriguez on behalf of Joseph Thompson.
Your name, sir?
Joseph Thompson.
Thank you.
And Your Honor, we're asking for a preliminary examination. To my knowledge, discovery is complete.
And would people have their witnesses available on the 7th? All right, preliminary examination in person will be July 7th, 2026, 9 a.m. before Judge Freshour. Bond continued. Thank you, sir.
Thank you, sir.
Thank you, Your Honor.
Court calls case People versus Trayvon Bridges.
From Your Honor, Freeman Cook for the people.
No, we'll wait.
I can, Judge. Assistant Public Defender. The leader on behalf of Mr. Trayvon Bridges. Mr. Bridges, state your name for the record, please.
Trayvon Bridges.
Thank you.
Thank you. Your Honor, we're asking for an adjournment in this matter. I was just on the phone with Mr. Bridges, but we just, one last conversation and we'll have a resolution.
What? You tried to sneak one in? You seriously?
I think he does it on purpose.
Hold on, Bridges. Don't worry about it. You're okay. Why'd you try to sneak it up?
I think he does it on purpose.
Who does it? Oh, this was for the one like a long while back. Okay, so take that one. I think the file might be gone already on the shelf. All right. You want an adjournment on this one, right?
Judge, please.
All right. I'll adjourn this one to July 6th, 2026, 9 a.m.
Thank you.
All right. Thank you, sir.
You're welcome. Have a good day.
You too. Court calls the case of the People versus Christina. Is it Eichard?
Good morning, Your Honor. Marcia coming on behalf of Eichard. She's on Zoom, Your Honor.
Could you state your name, please?
Christina Joe Eichard.
Thank you.
We are in receipt of the competence evaluation. It's my understanding my client has been found competent to speak from, and we have no objection to the report and request the court to set a proper cause.
We'll also stipulate to the report.
That's
all right. Based upon the report, the court would find that the defendant is competent to stand trial. Specifically, the court would find that the defendant can understand the nature and objects of the proceedings against her and can rationally assist in her defense. Therefore, the defendant is deemed competent. Counsel, I'll need an order.
Okay, thank you.
Today, we'll need it.
Yes, absolutely.
All right. I'll set probable cause conference in this matter then for July 9th, 2026, 9 a.m. Round continues.
Thank you.
Thank you. Court calls case People versus De Jure Bond Sanders.
Allison on behalf of the people. Stephanie Cannon on behalf of Mr. Bond Sanders, who is approaching, Your Honor.
Your name, sir? Angela Bossanis. Thank you.
Your Honor, we're asking that this matter be set for preliminary exam. In addition, when appropriate, I would like to address bond.
Discovery is complete.
Yes, Your Honor.
Go ahead. Their witnesses available the 7th. Preliminary examination, July 7th, 2026, 9 a.m. before Judge Perry. As to bond.
Your Honor, I have provided the prosecutor with an order for release to treatment. And my client has a substantial drinking history and drinking problem, which I do believe contributes a great deal to why he continues to be before the court. It's my understanding, I believe they're going to object, but I do have the order for
people. What?
I believe they're going to object to release to treatment.
Go ahead.
Joe Paulski was calling the victim. The court is well aware they revoked his bond and his phone calls, but the last week told the victim as he was leaving court, because she wasn't present, that he loved her in the courtroom. And then after he got back to the jail, he then made one more phone call to her. He said he blocked her number. So I'm given that while he is in custody and not drinking, he still can't follow court orders.
Anything else, Ms. Me?
Again, Your Honor, I do believe a lot of this just stems from his substance abuse and some mental health problems that he and I have discussed. And in this case, I think to prevent the revolving door that is him, treatment is going to be our best option. And I'm just asking that we be allowed to start it.
I'm not going to sign it. All right.
Understand?
Okay.
Yes, the second.
Court calls case people versus Donovan Buckner. Yes.
People, Your Honor. Assistant Public Defender. To not be chair, I can't really, Your Honor. Donovan Buckner. Judge, I have not been able to make contact with Mr. Buckner.
Oh. If I walk real slow and talk real slow, you Buckner. Nope. Bench warrant will issue for defendant's failure to appear bond 10,000 cash surety. That warrant will issue immediately.
Thank you.
Court calls the case of the people versus Justin Heaton.
We're going to do it for this people, Your Honor.
Oh, but on behalf of Mr. Heaton.
Sir, your name?
Justin Heaton.
Thank you. What are we doing?
Your Honor, I was just appointed yesterday, so I am asking for a brief adjournment for discovery and plea negotiations. I'd also like to make a bond argument when the court finds it appropriate.
Has he been, all right, well, I'll adjourn it to July 9th, 2026, 9 a.m. Before you go about addressing bond, has he been assessed? Has there been a CMH assessment?
May I ask if that's part of bond?
Pardon?
May I ask that happens as part of bond so that it's all wrapped up into one?
I was just asking. I thought so. So you want me to prepare an order so that you can have a CMH assessment? Is that okay?
Yes, so that I could.
I thought that was already arranged, but apparently that didn't get done. So I need an order that the defendant should be assessed by CMH because his bond at the last bond hearing or the last hearing, I said I would reconsider his release once there was an assessment.
Understood.
So at this point, bond will continue, but get that order into me.
I'll prepare that order today, Judge.
They did mention that we could handle that after outside of jail.
Yeah, I know what I got that. There are two ways of doing it, and I just wanted it done this way. All right. All right. And Mr. Burdell, you're aware of just so that we're clear of the housing issues.
It's been brought to my attention, yes.
Okay.
I'm still up to speed on it, but it has been brought to my attention.
Got it. Okay. Thank you. Courthouse case, people versus Jalen Carter.
Great, doing for the people here. Ashley this year on behalf of Jalen Carter.
Oh, my goodness.
Hi.
Hello, long time no see.
No, yeah, I'm happy to be here. But unfortunately, I have not been able to get in touch with Mr. Carter.
So you're here after not being here and you don't have a client.
I'm very sorry.
And know what?
I
More like Chinasa.
I do have a green sheet, but I was going to request an adjournment or an opportunity to get in touch with him. For a possible delay before a bench warrant if one is issued.
Do what?
I was going to ask for an adjournment or as an alternative, 48 hours to get in touch with Mr. Carter.
They've got you in Ann Arbor, don't they?
I'm in Chelsea and Saline.
You're what?
I'm in 14A3 and 4 now.
Oh, are you? They do that out there?
I'm not sure yet, actually.
Yeah. Oh, so you just got to Chelsea.
Yeah.
You were in Ann Arbor.
Yeah.
Is this very much an Ann Arbor request? Bench warrant will issue for the defendant's failure to appear. All right, I'll give 48 hours. Bench warrant will issue 29th.
Thank you, Your Honor.
You're welcome. Nobody else gets that. Or it calls the case, people versus Clarence West.
Great, doing for the people here.
David I. Goldstein appearing on behalf of the defendant.
Your name, sir?
Clarence Alexander West.
Yes, sir.
Your Honor, I do have written discovery in this matter. There are videos, I believe, that I have not. Are there videos? So if we can just have a week so I can goes.
All right. Probable cause conference will be adjourned to July 2nd, 2026, 9 a.m.
Your Honor, what do you show as this status bond?
Bond. I have a PR in case. Yeah, I have a PR.
Your Honor, he has a PR bond here. He also has a case in Wayne County in which there's PR, and yet they're holding him. We can't figure out why.
Was our PR conditioned on a tether?
Yeah. Was?
You were supposed to get a tether.
Okay, that may be the problem then.
Well, no, it shouldn't be.
I also know he has olds and
Yeah, at Wayne County that's been taken care of.
I have Van Buren and Livonia behind, right?
Livonia, the Van Buren is, we appeared there and they said a PR bond. There is nothing in Livonia. We called the police department, we called the court, and there's nothing there.
I checked extra as of yesterday, but I don't know if they don't.
No, I've got it. I've got to know
that, but in any event, that's the reason, because what they won't do is they're not going to put a tether on him where he's then going to go someplace.
So I understand that, Your Honor. What we can't figure out is I've got an email from the court in Livonia saying there's no hold, and yet a hold shows. We can't figure out what the deal is. So anyway,
I got you, but I don't know that there's anything I can do to try to
go to Livonia,
fix that. But I think you have something from the court indicating that there is not a hold.
Right. And if you look up,
maybe present that to the jail. I'm just offering that maybe they will look at it and they'll say, well, really isn't a hold, and then put him on a tether and release it.
We'll try that, Your Honor.
All right.
Thank you.
Thank you. If I adjourned it to the second. Have you been presented the letter? Okay, so once you guys have that, even if you fashion an order for my signature to present to the jail, I'll do that if upon review of that. Okay, if that'll help. Court does call the case, People versus Rodney Clark.
Defender Dodd, you leave both from Mr. Clark, Your Honor. Yeah.
Oh, I'm sorry. Not sure.
He is not checked in.
Oh, Your Honor, I did speak to him yesterday. I would ask the court consider passing the matter.
Mention warrant will issue for defendant's failure to appear.
Thank you.
Fine, 10,000 cash surety. Warrant will issue immediately. Court calls the case, People versus Benlea Winter.
Are you reading 15 people?
Defender on behalf of Benlea Winter. Oh, I'm sorry. Ms. Winter is approaching.
Your name?
Correct.
Benlea Winter.
All right. Just competency hearing. I have the competency report. Is there anything additional from the parties?
No, Your Honor, you were stipulated to the report.
Mr. Getty,
Yes, Your Honor, we would.
all right. I would stipulate that the report indicates that the defendant is competent to stand trial. Court would indicate that upon review of the report, the defendant can understand certain objects of the proceedings against her and can rationally assist in her defense. Therefore, the defendant is deemed competent, and I've signed that order. What would you like me to set this for?
We asked for
Set a probable cause conference for July. Is this the only case holding her? No, you got something.
I have a PR on the other one. Sorry.
There's a PR on your other case?
Sure.
Well, there's a.
Your Honor, I'm seeing look like there's 2 out of 1. There's one from else fine. The girl one's just a traffic offense, but the Novi one is drug related.
I reached out to Novi. I sent them a letter. And
Pardon?
I reached out to Novi personally. I sent them a letter. And they just sent me back a letter by itself. I plan on going, if I get released, to handle that.
And as far as the county, Your Honor, we've seen that there is an illusion. I believe 14B, like concept of offense.
Out of 14B.
That's what actually.
Well, what I'll do is I'll adjourn this to the 9th, 2025, or 2026, I'm sorry, 9 a.m. I will. You have 25,000 cash surety because there was. It usually indicates to me that there's.
Looks like there was a bench warrant in this case, Your Honor.
Yes, and I'm not. Oh, that's why.
I was seeing psychiatric help during the time, I think, around of this. I completely forgot about this incident.
Okay, hold on a second. Okay. I don't need you to go into detail, but where are you with your mental health treatment?
Honestly, I didn't get the correct mental health services until I came here. I was involuntarily withheld a couple of times at Havenwick Hospital, and they gave me meds that weren't working. Here, I was able to work with a psychiatrist to find medication that help, and I've been on medication, yes, since March.
Since March?
Yes.
Okay, and you're continuing on those medications now?
Absolutely.
Okay, hold on a second. That was in March of this year?
Yes.
Anything else regarding this defendant's fund?
Yes, Your Honor. Ms. Whitner.
So if you're ahead, you're gonna talk?
What?
Go ahead.
Sorry, Your Honor.
Thank you.
I'm sorry.
No, we're waiting.
She does have people in the community. She has a brother and a sister who live in Ypsilanti. Plans can't continue with CMH as reported. She's working with the reentry program. There is a pharmacy that's already been identified on Michigan Avenue that can fill her prescriptions. And they've made arrangements for her meds to go there.
I could have issued this like an hour ago, but it's okay. Go ahead. I'm listening.
Nothing further.
Thank you. Motion for bond reduction is granted. I'll set your bond at a personal recognizance. $25,000 bond. Just make sure you show back up. You hear me?
Sure.
All right. Thank you.
I don't win off in your.
No, it was a brilliant argument. Court calls case People versus Tommy Lee Clark Jr.
So for the people here, Stephanie Tan on behalf of Mr. Clark. You should be appearing by Zoom.
Mr. Clark, could you please state your name for the record?
Clark can't appear via Zoom.
I'm sorry, Your Honor. Mr. Clark, could you say your name?
Tommy Clark.
Your Honor, we are requesting an adjournment in this case. My client was released yesterday. I didn't have the opportunity to speak with him. We're just asking for an adjournment.
Got it. Okay. So what were you asking for?
An adjournment?
He's got to get himself, because he's out right now. He
He got out yesterday. Yes, Your Honor.
needs to get himself to community corrections. I have a violation report because they didn't show that he was in.
Oh,
I know.
okay. But Your Honor, he was in. Mr. Clark.
I know that.
Okay, you need to come to Washtenaw within the next 24 hours and meet with community to corrections, okay?
All right. Okay. So I'll adjourn this out to the 16th, July 16th, 2026, 9 a.m. On continued. Thank you. Court calls the case People versus Benny Sims.
Allison, on behalf of people.
Assistant Public Defender Dovey Leap on behalf of Mr. Sims. And it looks like he's appearing by Zoom from the jail, Your Honor. Mr. Sims, can you state your name?
That's not fair.
Sims, they're calling your case.
Mr. Sims?
The judge is calling you, Sims.
I must be in person in front. I fucking told me that. I know he's
All right.
in front.
All right.
They're calling your case.
Well, that is Mr. Sims. What are you trying to do on this case?
Your Honor, I was going to be setting it for a preliminary examination, please.
Okay. Discovery is complete.
It is, Your Honor.
People have their witnesses available to 7.
Sure, Your Honor.
All right. Preliminary examination will be set for July 7th, 2026, 9 a.m. before Judge Fresh Hour.
Thank you, Your Honor.
On Sims. Court calls case People versus Vincent Freeman II.
Allison, on behalf of people, Your Honor.
Michael Gaddy, Assistant Defender on behalf of Mr. Freeman. And
Mr. Freeman, a second.
yeah, we'd like to set this matter.
All right.
If I could be heard.
Discovery is complete.
Yes, the best of my knowledge, Judge.
People have their witnesses available to 7. Preliminary examination will be set July 7th, 2026, 9 a.m. before Judge Perry.
Your Honor, if I could be heard on bond.
Please. Yeah.
Yes, Your Honor, Mr. Freeman is obviously here. There's 3 holds. They're traffic. I don't think there's things that they're going to pick him up on. The bond is currently set at $10,000 cash. He is the complaining witness do not reside together. He resides in fact, in Detroit on Ellsworth, and reports that he can return to that address where he's lived for the last 5 years. So I don't think there's any issue in terms of physical contact between the two of them. There are bond conditions, including a GPS tether that could be used to track his location so that there is no concern so that the court's any concern about contact would be elite. And the court more reassured that he would comply with any reasonable conditions the court sets.
Rounds.
Okay, Jackie, I do have this about, that he had 3 calls made to the after his brain with 2 being complete from his pen. So I don't need to follow court orders. I do also have concerns given that this is a case where he punched out the front windshield and back windshield of her car with his hands and then resisted officers. And I believe he could be a danger to be given that he can't follow conditions while in custody as well.
Yeah, I have not heard those calls. So
Motion for bond reduction is denied. Bond will continue.
Thank you.
Court does call the case People versus Deborah Collette.
Assistant Public Defender Zach Green with on behalf of Ms. Collette, who should be present via Zoom. Ms. Collette, can you please unmute and state your name for the record?
Okay, I'll pass this back.
Thank you, Your Honor.
Court does call the case People versus Tyrese Pitts.
Morning, Your Honor. Raymond Cook for the panel.
I'm sorry, Your Honor. Attorney Sharon Jones, P number 57113 on behalf of Mr. Pitts, who is in the jail approaching. And Mr. Pitts, if you could please say your name.
Tyrese Pitts.
Your Honor.
All right. Yes.
Today is the date and time for the PCC and also for hearing on a bond motion I filed that is regarding a funeral. We are asking to set this matter for exam.
Is discovery complete?
It is, Your Honor. It appears to be complete.
People have their witnesses available the 7th?
Yes, Your Honor. We'll do about it.
All right, preliminary examination will be set July 7th, 2026, 9 a.m. before Judge Freshour.
Your Honor, if I may, the co-defendant's case was also set for exam that day before Judge Perry. Would it be possible to keep these 2 cases together? It would be the same.
Oh, yes.
Thank you.
We'll do that. So the co-defendant's already been sent before Perry.
That's correct, Your Honor.
All right, so we'll make this before Judge Perry. And then as to bond, did you?
Your Honor,
Go ahead.
a family member died and the funeral.
Yes, go ahead.
I believe my client's family member's funeral is tomorrow. So he is asking that he may be allowed to attend his loved one's funeral and say his last goodbyes.
I don't. Any response from the people? I don't know. Did you get a copy of this one?
I do not have a copy. If there was a written motion filed, I do not have a copy of that. I'm checking as I saw on the docket, it looks like it was a motion set. I did not see one in our file nor in my report, so I was unaware of what exactly the motion was. Regardless, I would be objecting to any change or release at this time. This is a case where defendants, along with a number of other individuals, were fleeing from police and what I believe ended up being a stolen vehicle after a shooting out of county that 120 miles an hour on the highway past them on the right, going through the red lights. When police eventually found the defendant after they fled on foot from that vehicle, he was hiding in an apartment. I would also note that this defendant has numerous prior convictions that give me reason to believe that he is a danger to the community. I'm seeing as far back as 2016, I believe. There's a felonious assault. I have convictions for, excuse me. Scroll down here. CCW, receiving concealing a motor vehicle, malicious destruction of police and fire property. One, 2023, felon in possession of a firearm. 5, it looks like there's another conviction, or sorry, no, those were just found over. I don't know what the disposition of those charges are, so I'll leave those off. At 2026, the defendant has a fleeing and eluding in 3rd degree, as well as a recent CW conviction. So I have concerns that this defendant proves to be a flight risk as well as a danger to the community. I sympathize with the defendant and the loss of a loved one if I don't believe that release is appropriate at this time.
Your Honor, and my client currently is not facing any type of charges alleging that he fled from police. My understanding is that the arrest was in an apartment building or apartment complex.
After they got out of the car and ran to it, and the police followed them there. I realized they may not have charged that, but.
Well, Your Honor, all I can say regarding the charges is that my client disputes that, but this is his last chance to say goodbye to his brother. And it would seem to me that if he could have some sort of escorted opportunity to attend the funeral, that.
And Your Honor, just for some additional context, as far as the firearms involved in this case, pursuant to a search warrant, police received a box of Hornby .40 caliber ammunition, an AR-15 magazine, an AK firearm with a double magazine, an AR-15 rifle with a magazine and shell catcher, an AK hell pup with a magazine, a Glock 17, a .40 caliber Glock magazine, a 9mm Glock magazine, and a Glock 22 handgun.
All right. I'm not going to let this, I understand and I feel for the defendant, but I'm not going to allow release at this time. His bond will continue. Thank you.
Okay.
So
thank you. I'd also filed a motion for a team member to go interview Mr. Pitts at the jail.
For who?
An investigator. I think I submitted a proposed order just for them to be able to visit him at the jail to do an interview to assist me because of the volume of discovery.
I don't have a copy of that motion either, so I'm not able to.
So I don't, counsel, I'm not, you got to send a copy of your motion to the prosecutor's office, because this is now the second one that they don't have for whatever the reason.
They're in the email. I sent it to your court and to the prosecutor's office. Both.
She did what?
The prosecutor's office.
So you sent it to the generic email for the prosecutor's office, didn't get a name?
I sent it to the only email I had for their office.
Okay, well, I'm not going to address, if they don't have a copy, I'm not going to address it because that puts them behind the 8 ball because they don't have the information. But so I'm not going to address that motion. All right, thank you.
Thank you, Your Honor. May I ask, do I just send it to the prosecutor that just spoke? Is that the correct individual at this point, or would it be a different prosecutor since it's before Judge Perry now?
Ma'am, you can send it to me and I can give you my email. Once we're off the record, I can shoot you an email because I believe I have your email.
Okay, thank you. I would appreciate that.
Thank you.
Have a good day, everyone.
Court call case, People versus Danina Combs.
Brian Bowling on behalf of Ms. Combs. Can you state your name for the record, please?
Danina Combs.
Your Honor, I'd like Ms. Combs to be screened for entrance to the recovery court at the court level. So I'm asking for an adjournment to do that. I will, before I submitted the referral form, I wanted to get the next court date, so I haven't done it yet, but it will go out shortly.
You think you can get that accomplished by the 16th, or you need more time? Or we're gonna.
I would say probably better, from what I hear, that maybe go a little further into July if possible.
The 23rd or 30th, which one would you like?
Let's do the 30th.
All right. So I'll adjourn to July 30th, 2026, 9 a.m.
Perfect. Thank you.
Thank you. Bond continue. Court does call the case People versus Wilnisha Crosby.
Where's on?
Assistant Public Defender Dobbs, you both form Ms. Crosby, who appears via Zoom.
It's been dropping and cheaper.
She's been dropping. She's not in. I'll pass it.
Thank you, Your Honor. She currently in.
Court calls case People versus Vasquez Davis.
For the people.
How about David?
How you doing today? My name is Vasquez Davis. How you feeling?
I'm doing all right. How you doing, man?
My day be better if yours good.
What'd you say?
I said my day would be better if yours good.
Okay.
Your Honor, the people have extended an offer. I understand that it's been adjourned a number of times. We do need to verify some things with third parties to Mr. Davis to respond to the offer. I'm requesting a 2-week adjournment.
2 weeks or you want 3? He's out.
3 weeks, it would be great, actually. Thank you.
I'll give you 2. No.
Okay.
July 16, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case of the People versus Cynthia Duplessis.
Hello, Your Honor.
Good morning, Your Honor. Attorney Nicholas Somberg on behalf of Cynthia Duplessis.
All
Cynthia
right.
Duplessis.
Thank you. All right, what are we doing?
You're going to be waiving the preliminary exam in this case.
You're waiving?
Yes.
All right. Ma'am, is that correct?
Yes.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
All right. People also waive the right.
Yeah.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count. Counsel, you acknowledge receipt of the information, waive its reading?
Yes, Your Honor.
Your client stands mute at this time?
Yes, Your Honor.
Defendant having waived former reading standing mute, court will enter a not guilty plea. Pretrial will be set for
19th at 1:30 with Judge Conlon.
August 19, 2026, 1:30 before Judge Conlon.
Thank you.
Bond will
Thank you, Your
continue.
Honor.
Yes, you may. Court does call the case People versus Riley Everett.
Your Honor, Raymond Cook for the people. Public Defender Dobbs, you leave out form Mr. Everett.
Can you unmute and state your name, sir?
Thank you.
Sir, what's your name? What's your name? Mr. Everett, what's your name? Yeah, I can't hear.
Yes, and that is Mr. Everett.
All right. Mr. Everett, can you give me a thumbs up if you can hear me? All right, real good. I'm going to adjourn your case out to July 16, 2026, 9 a.m. Okay, you got that? Okay, fantastic. You gave a thumbs up. Bond will continue.
Thank you, Your Honor.
Here. Court calls case People versus Robin Finney.
Case are not people, Your Honor.
Brian Mulling on behalf of Ms. Finney, Your Honor. Hoping she's on Zoom, maybe?
Yep. Not here.
All right. Well, Judge, I spoke to her on Monday. I expected her to be here today, but as you see, I'm sitting here by myself. So I would ask you to consider adjourning it. We didn't have any discovery. I didn't have it as of this morning, so that's what I was going to ask. But obviously I'll leave it Unfortunately.
I will leave it to the court's discretion.
Seriously? Bench warrant will issue 10,000 cash. Thank you. Court calls the case, People versus Ivor Hill.
Michael Gaddy is public defender. I'm Mr. He is approaching.
It's right behind you. Your name, sir? Ivor Hill. Thank you.
Your Honor, we're asking for a brief adjournment to discuss this matter further with the people and
July 16th, 2026, 9 a.m.
Thank you.
All right.
Oh, Your Honor, we do have an order for fingerprints. I don't know if the court has it. We have
I probably don't. If you
we may approach, we
got it taken care of.
Yes, Your Honor.
All right. Yeah. Court calls the case, People versus Joanne Jones.
Assistant Public Defender Davi Lebo for Mr. Jones, who's standing to my right.
Go on, Jones. Thank you.
And Your Honor, discovery is completed. We'd like to please set this matter for preliminary examination.
Okay. People, would people have their witnesses available to 7?
We'll do our best, Your Honor.
Preliminary examination will be in person, July 7th, 2026, 9 a.m. before Judge
Freshour.
Freshour.
Thank you, Your Honor.
On continued. Court calls case, People versus Stephen Klein.
Your Honor, agreement with this peaceful.
Michael Gaddy, public defender on behalf of Mr. Klein, Your Honor. I'm hopefully looking at the Zoom screen. Your Honor, we have called him. We've called in the hallway and in the courtroom. I don't have any explanation as to his whereabouts. I was going to ask for an adjournment. I've completed the green sheet, which is really 3/4 of the work on this. I'd ask the court for an adjournment.
Bench warrant will defendant's failure to appear bond is setting about $10,000 cash surety.
Thank you, Your Honor.
Court calls the case, People versus Austin Messier.
Your Honor, agreement with the people.
Your Honor, Michael Gaddy, Assistant Public Defender on behalf of Mr. Messer. Your Honor, we have called him. This is an odd situation where he was released. I did check VineLink. I thought maybe he was going to another jail. I didn't see him there. We've had no contact with him.
Bench warrant will issue bond 10,000 cash surety. Warrant will issue immediately. Court does call the case of the People versus Joseph Webster.
People, Your Honor. Webster, however, I don't. When I went to the jail yesterday, Your Honor, they told me that he had just been released to treatment. So I have to confirm that, but I believe.
On this case?
Yes.
They said he was released to treatment.
They told me that he had just got on the transport. So let me rephrase that, Your Honor. They told me he had just been put on transport. I assumed it was for treatment.
Oh, I see. But we don't know.
Right.
I'll let you try to figure it out. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash or surety. I won't issue the warrant until the 29th.
Your Honor. Thank you.
Yeah. And then that's it, right? Except my recalls, but are they here? Crosby's here. Got it. Or recalls the case, People versus Nisha Crosby.
Public Defender Davi Lebo for Ms. Crosby.
Good morning, Your Honor. Nisha Crosby.
Thank you.
And Your Honor, I'm requesting adjournment. I did submit some engaged information to the prosecutor yesterday. I'm just waiting for them to review it.
Peace probable cause conference will be adjourned July 16th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. And what about our other ones? You have it. Okay. Court calls the case of People versus Deborah Collette.
Your Honor.
Assistant Public Defender Zach Vinu with our hopefully with and on behalf of Ms. Collette, who would be present via Zoom. She just texted me that she thinks that she's in the Zoom.
Ms. Collette. There's someone on our screen, a Samsung SM. Could you tell me who you are?
And she stated she's in a pink and white shirt. I don't know if she's on video.
In a pink and white shirt? Well, that's nice. I don't have a camera. Oh, last no. You're in communication with her.
Yes, Your Honor. I can.
So ask her if her screen shows her name as Samsung.
I can give her a call and try to put her on speaker. Would that be helpful? Or
no? Okay.
But Your Honor, we would be requesting an adjournment in this case.
I just don't know if she's here. I mean, I understand what you're saying, but
she is texting. Your Honor, may I briefly step back to try to call her?
I'll put this over into the next block and you can call her, have a great conversation and everything. Okay. All right. Thank you. That's it.
Hello, Judge.
Oh, hello. Who are you?
This is Rodney Clark. I'm at work and I think I got missed.
Did I issue a bench warrant already?
Yeah. Just text my lawyer. He said you did. I mean, I was on here and I guess I don't know what happened. I was on here earlier.
You just signed in, so don't say you're on here because I won't even try to recall your case if you're not telling me the truth.
I'm definitely telling the truth. I called in for it was another phone. It was what is it? It's an Android phone. I was on there. I was definitely on there. From an Android, a Moto G. It was like a Moto G was on there.
I don't have a file anymore.
Do you want me to get it?
No. I mean, yeah, get it. I'll call it up in the next block with this one. So you're going to have to wait till my next block, but we'll get you called up.
It's no problem, sir. No problem, Jan. Thank you.
That's everything.
Yes. Okay.